Section 20 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Jennifer Fournier, Marshall, Virginia. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller. Section 20. Legal defenses to the application of obstruction of justice statutes to the President. The President's personal counsel has written to this office to advance statutory and constitutional defenses to the potential application of the obstruction of justice statutes to the President's conduct. As a statutory matter, the President's counsel has argued that a core obstruction of justice statute, Title 18, United States Code, Section 1512, subsection C2, does not cover the President's actions. As a constitutional matter, the President's counsel argued that the President cannot obstruct justice by exercising his constitutional authority to close Department of Justice investigations or terminate the FBI director. Under that view, any statute that restricts the President's exercise of those powers would impermissibly intrude on the President's constitutional role. The President's counsel has conceded that the President may be subject to criminal laws that do not directly involve exercises of his Article II authority, such as laws prohibiting bribing witnesses or suborning perjury. But counsel has made a categorical argument that the President's exercise of his constitutional authority here to terminate an FBI director and to close investigations cannot constitutionally constitute obstruction of justice. In analyzing counsel's statutory arguments, we concluded that the President's proposed interpretation of Section 1512C2 is contrary to the litigating position of the Department of Justice and is not supported by principles of statutory construction. As for the constitutional arguments, we recognized that the Department of Justice and the courts have not definitively resolved these constitutional issues. We therefore analyzed the President's position through the framework of Supreme Court precedent addressing the separation of powers. Under that framework, we concluded, Article II of the Constitution does not categorically and permanently immunize the President from potential liability for the conduct that we investigated. Rather, our analysis led us to conclude that the obstruction of justice statutes can validly prohibit a President's corrupt efforts to use his official powers to curtail, end, or interfere with an investigation. A. Statutory defenses to the application of obstruction of justice provisions to the conduct under investigation. The obstruction of justice statute most readily applicable to our investigation is 18 U.S.C. 1512C2. Section 1512C provides C. Whoever corruptly 1. alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so, with the intent to impair the object's integrity or availability for use in an official proceeding, or 2. otherwise obstructs, influences, or impedes any official proceeding, or attempts to do so, shall be fined under this title or imprisoned not more than 20 years, or both. The Department of Justice has taken the position that Section 1512C2 states a broad, independent, and unqualified prohibition on obstruction of justice. While defendants have argued that subsection C2 should be read to cover only acts that would impair the availability or integrity of evidence, because that is subsection C1's focus, strong arguments weigh against that proposed limitation. The text of Section 1512C2 confirms that its sweep is not tethered to Section 1512C1. Courts have so interpreted it. Its history does not counsel otherwise, and no principle of statutory construction dictates a contrary view. On its face, therefore, Section 1512C2 applies to all corrupt means of obstructing a proceeding, pending or contemplated, including by improper exercises of official power. In addition, other statutory provisions that are potentially applicable to certain conduct we investigated broadly prohibit obstruction of proceedings that are pending before courts, grand juries, and Congress. See 18 U.S.C. Sections 1503 and 1505. Congress has also specifically prohibited witness tampering. See 18 U.S. Code, Section 1512B. 1. The text of Section 1512C2 prohibits a broad range of obstructive acts. Several textual features of Section 1512C2 support the conclusion that the provision broadly prohibits corrupt means of obstructing justice and is not limited by the more specific prohibitions in Section 1512C1, which focus on evidence impairment. First, the text of Section 1512C2 is unqualified. It reaches acts that, quote, obstruct, influence, or impede any official proceeding, end quote, when committed, quote, corruptly, end quote. Nothing in Section 1512C2's text limits the provision to acts that would impair the integrity or availability of evidence for use in an official proceeding. In contrast, Section 1512C1 explicitly includes the requirement that the defendant act with the intent to impair the object's integrity or availability for use in an official proceeding, a requirement that Congress also included in two other sections of Section 1512. See 18 U.S. Code, Sections 1512A2B2, use of physical force with intent to cause a person to destroy an object, with intent to impair the integrity or availability of the object for use in an official proceeding. 1512B2B, use of intimidation, threats, corrupt persuasion, or misleading conduct with intent to cause a person to destroy an object with intent to impair the integrity or availability of the object for use in an official proceeding. But no comparable intent or conduct element focused on evidence impairment appears in Section 1512C2. The intent element in Section 1512C2 comes from the word corruptly. See e.g. United States v. McGibbons, 656 F. 3rd 707 at 711, 7th Circuit 2011. The intent element is important because the word corruptly is what serves to separate criminal and innocent acts of obstruction. And the conduct element in Section 1512C2 is obstructing, influencing, or impeding a proceeding. Congress is presumed to have acted intentionally in the disparate inclusion and exclusion of evidence impairment language. See Logren v. United States, 573 U.S. 351 at 358, 2014. When Congress includes particular language in one section of a statute, but omits it in another, let alone in the very next provision, this court presumes that Congress intended a difference in meaning. Quoting Russello v. United States, 464 U.S. 16 at 23, 1983. Accord, Digital Reality Trust, Inc. v. Summers, 138, Supreme Court, 767 at 777, 2018. Second, the structure of Section 1512 supports the conclusion that Section 1512C2 defines an independent offense. Section 1512C2 delineates a complete crime with different elements from Section 1512C1, and each subsection of Section 1512C contains its own attempt prohibition, underscoring that they are independent prohibitions. The two subsections of Section 1512C are connected by the conjunction or, indicating that each provides an alternative basis for criminal liability. See Logren, 573 U.S. at 357. Ordinary use of or is almost always disjunctive. That is, the words it connects are to be given separate meanings. In Logren, for example, the Supreme Court relied on the use of the word or to hold that adjacent and overlapping subsections of the bank fraud statute, 18 U.S.C. Section 1344, state distinct offenses, and that subsection 1344-2, therefore, should not be interpreted to contain an additional element specified only in subsection 1344-1. Id. See also Shaw v. United States, 137, Supreme Court, 462, at 465 through 469, 2016, recognizing that the subsections of the bank fraud statute overlap substantially, but identifying distinct circumstances covered by each. And here, as in Logren, Section 1512C's two clauses have separate numbers, line breaks before, between, and after them, and equivalent indentation, thus placing the clauses visually on an equal footing and indicating that they have separate meanings. 573 U.S. at 359. Third, the introductory word otherwise in Section 1512C2 signals that the provision covers obstructive acts that are different from those listed in Section 1512C1. See Black's Law Dictionary, 1101, 6th edition, 1990. Otherwise means in a different manner, in another way, or in other ways. See also, e.g., American Heritage College Dictionary Online. 1. In another way, differently. 2. Under other circumstances. See also Gooch v. United States, 297 U.S. 124 at 128, 1936, characterizing otherwise as a broad term and holding that a statutory prohibition on kidnapping for ransom or reward or otherwise is not limited by the words ransom and reward to kidnappings for pecuniary benefits. Colossos v. United States, 368 F. 3rd 190 at 200, 2nd Circuit, 2004. Construing otherwise in 28 U.S. Code Section 2466 1C to reach beyond the specific examples listed in prior subsections, thereby covering the myriad means that human ingenuity might devise to permit a person to avoid the jurisdiction of a court. Cf. Begay v. United States, 553 U.S. 137 at 144, 2006, recognizing that otherwise is defined to mean in a different way or manner, and holding that the word otherwise, introducing the residual clause in the Armed Career Criminal Act, 18 U.S. Code, Section 924 E2B2, can, but need not necessarily, refer to a crime that is similar to the listed examples in some respects, but different in others. The purpose of the word otherwise in Section 1512C2 is therefore to clarify that the provision covers obstructive acts other than the destruction of physical evidence with the intent to impair its integrity or availability, which is the conduct addressed in Section 1512C1. The word otherwise does not signal that Section 1512C2 has less breadth in covering obstructive conduct than the language of the provision implies. 2. Judicial decisions support a broad reading of Section 1512(c)(2). Courts have not limited Section 1512(c)(2) to conduct that impairs evidence, but instead have read it to cover obstructive acts in any form. As one court explained, this expansive subsection operates as a catch-all to cover otherwise obstructive behavior that might not constitute a more specific offense like document destruction, which is listed in C1. United States v. Volpodesto, 746 F. 3rd 273 at 286, 7th Circuit, 2014. For example, in United States v. Ring, 628 F. Sup. 2nd, 195, District Court for the District of Columbia, 2009, the court rejected the argument that Section 1512(c)(2)'s reference to conduct that otherwise obstructs, influences, or impedes any official proceeding is limited to conduct that is similar to the type of conduct prescribed by subsection C1, namely, conduct that impairs the integrity or availability of records, documents, or other objects for use in an official proceeding. Id. at 224. The court explained that the meaning of Section 1512(c)(2) is plain on its face. Id. And courts have upheld convictions under Section 1512(c)(2) that did not involve evidence impairment, but instead resulted from conduct that more broadly thwarted arrests or investigations. See e.g. United States v. Martinez, 862 F. 3rd 223 at 238, 2nd Circuit, 2017. Police officers tipped off suspects about issuance of arrest warrants before outstanding warrants could be executed, thereby potentially interfering with an ongoing grand jury proceeding. United States v. Arensfield, 698 F. 3rd 1310 at 1324 through 1326, 10th Circuit, 2012. Officer disclosed existence of an undercover investigation to its target. United States v. Phillips, 583 F. 3rd 1261 at 1265, 10th Circuit, 2009. Defendant disclosed identity of an undercover officer, thus preventing him from making controlled purchases from methamphetamine dealers. These cases illustrate that Section 1512(c)(2) applies to corrupt acts, including by public officials, that frustrate the commencement or conduct of a proceeding, and not just to acts that make evidence unavailable or impair its integrity. Section 1512(c)(2)'s breadth is reinforced by the similarity of its language to the Omnibus Clause of 18 U.S. Code, Section 1503, which covers anyone who corruptly obstructs or impedes or endeavors to influence, obstruct, or impede the due administration of justice. That clause of Section 1503 follows two more specific clauses that protect jurors, judges, and court officers. The Omnibus Clause has nevertheless been construed to be far more general in scope than the earlier clauses of the statute. United States v. Aguilar, 515 U.S. 593 at 599, 1995. The Omnibus Clause is essentially a catch-all provision, which generally prohibits conduct that interferes with the due administration of justice. United States v. Brenson, 104 F. 3rd 1267 at 1275, 11th Circuit, 1997. Courts have accordingly given it a non-restrictive reading. United States v. Kumar, 617 F. 3rd 612 at 620, 2nd Circuit, 2010. Id. at 620, Note 7. Collecting cases from the 3rd, 4th, 6th, 7th, and 11th Circuits. As one court has explained, the Omnibus Clause prohibits acts that are similar in result rather than manner to the conduct described in the first part of the statute. United States v. Howard, 569 F. 2nd 1331 at 1333, 5th Circuit, 1978. While the specific clauses forbid certain means of obstructing justice, the Omnibus Clause aims at obstruction of justice itself, regardless of the means used to reach that result. Id. Collecting cases. Given the similarity of Section 1512c2 to Section 1503's Omnibus Clause, Congress would have expected Section 1512c2 to cover acts that produced a similar result to the evidence impairment provisions, i.e., the result of obstructing justice, rather than covering only acts that were similar in manner. Read this way, Section 1512c2 serves a distinct function in the federal obstruction of justice statutes. It captures corrupt conduct, other than document destruction, that has the natural tendency to obstruct contemplated as well as pending proceedings. Section 1512c2 overlaps with other obstruction statutes, but it does not render them superfluous. Section 1503, for example, which covers pending grand jury and judicial proceedings, and Section 1505, which covers pending administrative and congressional proceedings, reach endeavors to influence, obstruct, or impede the proceedings, a broader test for inchoate violations than Section 1512c2's attempt standard, which requires a substantial step towards a completed offense. See United States v. Sampson, 898 F. 3rd 287 at 302, Second Circuit 2018. Efforts to witness tamper that rise to the level of an endeavor, yet fall short of an attempt, cannot be prosecuted under Section 1512. United States v. Leisure, 844 F. 2nd 1347, at 1366 through 1367, 8th Circuit, 1988. Collecting cases recognizing the difference between the endeavor and attempt standards. And 18 U.S. Code, Section 1519, which prohibits destruction of documents or records in contemplation of an investigation or proceeding, does not require the nexus showing under Aguilar, which Section 1512c2 demands. See e.g. United States v. Yielding, 657 F. 3rd 688 at 712, 8th Circuit 2011. The requisite knowledge and intent under Section 1519 can be present even if the accused lacks knowledge that he is likely to succeed in obstructing the matter. United States v. Gray, 642 F. 3rd 371 at 376 through 377, 2nd Circuit 2011. In enacting Section 1519, Congress rejected any requirement that the government prove a link between a defendant's conduct and an imminent or pending official proceeding. The existence of even substantial overlap is not uncommon in criminal statutes. Logren, 573 U.S. at 359, Note 4. See Shaw, 137 Supreme Court, at 458 through 469. Aguilar, 515 U.S. at 616. Justice Scalia dissenting. The fact that there is now some overlap between Section 1503 and Section 1512 is no more intolerable than the fact that there is some overlap between the Omnibus Clause of Section 1503 and the other provisions of 1503 itself. But given that Sections 1503, 1505, and 1519 each reach conduct that Section 1512c2 does not, the overlap provides no reason to give Section 1512c2 an artificially limited construction. See Shaw, 137 Supreme Court at 469. 3. The legislative history of Section 1512c2 does not justify narrowing its text. Given the straightforward statutory command in Section 1512c2, there is no reason to resort to legislative history. United States v. Gonzalez, 520 U.S. 1 at 6, 1997. In any event, the legislative history of Section 1512C2 is not a reason to impose extra textual limitations on its reach. Congress enacted Section 1512C2 as part of the Sarbanes-Oxley Act of 2002, Public Law No. 107-204, Title IX, Section 1102, Volume 116, U.S. Statutes at Large, page 807. The relevant section of the statute was entitled Tampering with a Record or Otherwise Impeding an Official Proceeding, 116 Stat 807, emphasis added. That title indicates that Congress intended the two clauses to have independent effect. Section 1512C was added as a floor amendment in the Senate and explained as closing a certain loophole with respect to document shredding. See 148 Congressional Record, S. 6545, July 10, 2002, Senator Lott. Id at S. 6549-S. 6550, Senator Hatch. But those explanations do not limit the enacted text. See Pittston Coal Group v. Sieben, 488 U.S. 105 at 115, 1988. It is not the law that a statute can have no effects which are not explicitly mentioned in its legislative history. See also Encino Motor Cars, LLC v. Navarro, 138, Supreme Court, 1134, at 1143, 2018. Even if Congress did not foresee all the applications of the statute, that is no reason not to give the statutory text a fair reading. The floor statements, thus, cannot detract from the meaning of the enacted text. See Barnhart v. Sigmund Coal Company, 534 U.S. 438 at 457, 2002. Floor statements from two senators cannot amend the clear and unambiguous language of a statute. We see no reason to give greater weight to the views of two senators than to the collective votes of both houses, which are memorialized in the unambiguous statutory text. That principle has particular force where one of the proponents of the amendment to Section 1512 introduced his remarks as only briefly elaborating on some of the specific provisions contained in this bill. 148 Congressional Record, S. 6550, Senator Hatch. Indeed, the language Congress used in Section 1512C2, prohibiting corruptly obstructing, influencing, or impeding any official proceeding, or attempting to do so, parallels a provision that Congress considered years earlier in a bill designed to strengthen protections against witness tampering and obstruction of justice. While the earlier provision is not a direct antecedent of Section 1512C2, Congress's understanding of the broad scope of the earlier provision is instructive. Recognizing that the proper administration of justice may be impeded or thwarted by a variety of corrupt methods limited only by the imagination of the criminally inclined, Senate Report No. 532, 97th Congress, 2nd Session, 17 through 18, 1982. Congress considered a bill that would have amended Section 1512 by making it a crime inter alia when a person corruptly influences, obstructs, or impedes the enforcement and prosecution of federal law, administration of a law under which an official proceeding is being or may be conducted, or the exercise of a federal legislative power of inquiry. Id at 17 through 19, quoting S. 2420. The Senate committee explained that the purpose of preventing an obstruction of or miscarriage of justice cannot be fully carried out by a simple enumeration of the commonly prosecuted obstruction offenses. There must also be protection against the rare type of conduct that is the product of the inventive criminal mind and which also thwarts justice. Id at 18. The report gave examples of conduct actually prosecuted under the current residual clause in 18 U.S. Code Section 1503, which would probably not be covered in this series of provisions without a residual clause. Id. One prominent example was a conspiracy to cover up the Watergate burglary and its aftermath by having the Central Intelligence Agency seek to interfere with an ongoing FBI investigation of the burglary. Id. Citing United States v. Haldeman, 559 F. 2nd 31, D.C. Circuit 1976. The report therefore indicates a congressional awareness not only that residual clause language resembling Section 1512c2 broadly covers a wide variety of obstructive conduct, but also that such language reaches the improper use of governmental processes to obstruct justice, specifically the Watergate cover-up orchestrated by White House officials, including the President himself. See Haldeman, 559 F. 3rd at 51, 86 through 87, 120 through 129, and 162. 4. General principles of statutory construction do not suggest that Section 1512c2 is inapplicable to the conduct in this investigation. The requirement of fair warning in criminal law, the interest in avoiding due process concerns in potentially vague statutes, and the rule of lenity do not justify narrowing the reach of Section 1512c2's text. A. As with other criminal laws, the Supreme Court has exercised restraint in interpreting obstruction of justice provisions, both out of respect for Congress's role in defining crimes and in the interest of providing individuals with fair warning of what a criminal statute prohibits. Marinello v. United States, 138 Supreme Court 1101 at 1106, 2018. Arthur Anderson, 544 U.S. at 703. Aguilar, 515 U.S. at 599-602. In several obstruction cases, the Court has imposed a nexus test that requires that the wrongful conduct targeted by the provision be sufficiently connected to an official proceeding to ensure the requisite culpability. Marinello, 138 Supreme Court at 1109. Arthur Anderson, 544 U.S. at 707 through 708. Aguilar, 515 U.S. at 600 through 602. Section 1512c2 has been interpreted to require a similar nexus. See, for example, United States v. Young, 916 F. 3rd 368 at 386, 4th Circuit 2019. United States v. Petruk, 781 F. 3rd 538 at 445, 8th Circuit 2015. United States v. Phillips, 583 F. 3rd 1261 at 1264, 10th Circuit 2009. United States v. Reich, 479 F. 3rd 179 at 186, 2nd Circuit 2007. To satisfy the nexus requirement, the government must show as an objective matter that a defendant acted in a manner that is likely to obstruct justice, such that the statute excludes defendants who have an evil purpose but use means that would only unnaturally and improbably be successful. Aguilar, 515 U.S. at 601 through 602. See id at 599. The endeavor must have the natural and probable effect of interfering with the due administration of justice. The government must also show, as a subjective matter, that the actor contemplated a particular foreseeable proceeding. Petruk, 781 F. 3rd at 445. Those requirements alleviate fair warning concerns by ensuring that obstructive conduct has a close enough connection to existing or future proceedings to implicate the dangers targeted by the obstruction laws, and that the individual actually has the obstructive result in mind. B. Courts also seek to construe statutes to avoid due process vagueness concerns. See, for example, McDonald v. United States, 136 Supreme Court 2355 at 2373, 2016. Skilling v. United States, 561 U.S. 358 at 368. Also 402 through 404, 2010. Vagueness doctrine requires that a statute define a crime with sufficient definiteness that ordinary people can understand what conduct is prohibited, and in a manner that does not encourage arbitrary and discriminatory enforcement. Id at 402 through 403. The obstruction statute's requirement of acting corruptly satisfies that test. Acting corruptly within the meaning of Section 1512c2 means acting with an improper purpose and to engage in conduct knowingly and dishonestly with the specific intent to subvert, impede, or obstruct the relevant proceeding. United States v. Gordon, 710 F. 3rd, 1124 at 1151, 10th Circuit, 2013. The majority opinion in Aguilar did not address the defendant's vagueness challenge to the word corruptly, 515 U.S. at 600, Note 1. But Justice Scalia's separate opinion did reach that issue and would have rejected the challenge. Id at 616 through 617, Justice Scalia, joined by Justices Kennedy and Thomas, concurring in part and dissenting in part. Statutory language need not be colloquial, Justice Scalia explained, and the term corruptly in criminal laws has a long-standing and well-accepted meaning. It denotes an act done with an intent to give some advantage inconsistent with official duty and the rights of others. Id at 616. Internal quotation marks omitted, citing lower court authority and legal dictionaries. Justice Scalia added that, in the context of obstructing jury proceedings, any claim of ignorance of wrongdoing is incredible. Id at 617. Lower courts have also rejected vagueness challenges to the word corruptly. See, for example, United States v. Edwards, 869 F. 3rd, 490 at 501 through 502, 7th Circuit, 2017. United States v. Brenson, 104 F. 3rd, 1267 at 1280 through 1281, 11th Circuit, 1997. United States v. Howard, 569 F. 2nd, 1331 at 1336, Note 9, 5th Circuit, 1978. This well-established intent standard precludes the need to limit the obstruction statutes to only certain kinds of inherently wrongful conduct. C. Finally, the rule of lenity does not justify treating Section 1512c2 as a prohibition on evidence impairment, as opposed to an omnibus clause. The rule of lenity is an interpretive principle that resolves ambiguity in criminal laws in favor of the less severe construction. Cleveland v. United States, 531 U.S. 12 at 25, 2000. As the Court has repeatedly emphasized, however, the rule of lenity applies only if, after considering text, structure, history, and purpose, there remains a grievous ambiguity or uncertainty in the statute, such that the Court must simply guess as to what Congress intended. Abramsky v. United States, 573 U.S. 169 at 188, Note 10, 2014. The rule has been cited, for example, in adopting a narrow meaning of tangible object in an obstruction statute when the prohibition's title, history, and list of prohibited acts indicated a focus on destruction of records. See Yates v. United States, 135, Supreme Court 1074 at 1088, 2015, plurality opinion, interpreting tangible object in the phrase record, document, or tangible object in 18 U.S. Code, Section 1519, to mean an item capable of recording or preserving information. Here, as discussed above, the text, structure, and history of Section 1512c2 leaves no grievous ambiguity about the statute's meaning. Section 1512C2 defines a structurally independent general prohibition on obstruction of official proceedings. 5. Other obstruction statutes might apply to the conduct in this investigation. Regardless whether Section 1512C2 covers all corrupt acts that obstruct, influence, or impede pending or contemplated proceedings, other statutes would apply to such conduct in pending proceedings, provided that the remaining statutory elements are satisfied. As discussed above, the Omnibus Clause in 18 U.S. Code Section 1503A applies generally to obstruction of pending judicial and grand proceedings. See Aguilar 515 U.S. at 598, noting that the clause is far more general in scope than preceding provisions. Section 1503A's protections extend to witness tampering and to other obstructive conduct that has a nexus to pending proceedings. See Sampson, 898 F. 3rd at 298 through 303, and Note 6, collecting cases from 8 circuits holding that Section 1503 covers witness-related obstructive conduct, and cabining prior circuit authority. And Section 1505 broadly criminalizes obstructive conduct aimed at pending agency and congressional proceedings. See, for example, United States v. Rainey, 757 F. 3rd 234 at 241 through 247, 5th Circuit, 2014. Finally, 18 U.S. Code, Section 1512B3, criminalizes tampering with witnesses to prevent the communication of information about a crime to law enforcement. The nexus inquiry articulated in Aguilar, that an individual has knowledge that his actions are likely to affect the judicial proceeding, 515 U.S. at 599, does not apply to Section 1512B3. See United States v. Byrne, 435 F. 3rd 16 at 24 through 25, 1st Circuit, 2006. The nexus inquiry turns instead on the actor's intent to prevent communications to a federal law enforcement official. See Fowler v. United States, 563 U.S. 668 at 673 through 678, 2011. In sum, in light of the breadth of Section 1512C2 and the other obstruction statutes, an argument that the conduct at issue in this investigation falls outside the scope of the obstruction laws lacks merit. End of Section 20.
Section 21 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by ljarrow. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller. Legal defenses to the application of obstruction of justice statutes to the President. Section B. Constitutional defenses to applying obstruction of justice statutes to presidential conduct. The President has broad discretion to direct criminal investigations. The Constitution vests the executive power in the President and enjoins him to take care that the laws be faithfully executed. U.S. Constitution Article 2, Section 1, Paragraph 3. Those powers and duties form the foundation of prosecutorial discretion. See United States v. Armstrong, U.S. 517, 1996. Attorney General and United States Attorneys have this latitude because they are designated by statute as the President's delegates to help him discharge his constitutional responsibility to take care that the laws be faithfully executed. The President also has authority to appoint officers of the United States and to remove those whom he has appointed. U.S. Constitution, Article 2, Section 2, Clause 2, granting authority to the President to appoint all officers with the advice and consent of the Senate, but providing that Congress may vest the appointment of inferior officers in the President alone, the heads of departments, or the courts of law. See also Free Enterprise Fund v. Public Company Accounting Oversight Board, U.S. 561, 2010, describing removal authority as flowing from the President's responsibility to take care that the laws be faithfully executed. Although the President has broad authority under Article 2, that authority coexists with Congress's Article 1 power to enact laws that protect congressional proceedings, federal investigations, the courts, and grand juries against corrupt efforts to undermine their functions. Usually, those constitutional powers function in harmony with the President enforcing the criminal laws under Article 2 to protect against corrupt, obstructive acts. But when the President's official actions come into conflict with the prohibitions in the obstruction statutes, any constitutional tension is reconciled through separation of powers analysis. The President's counsel has argued that the President's exercise of his constitutional authority to terminate an FBI director and to close investigations cannot constitutionally constitute obstruction of justice. As noted above, no Department of Justice position or Supreme Court precedent directly resolved this issue. We did not find counsel's contention, however, to accord with our reading of the Supreme Court authority addressing separation of powers issues. Applying the court's framework for analysis, we concluded that Congress can validly regulate the President's exercise of official duties to prohibit actions motivated by a corrupt intent to obstruct justice. The limited effect on presidential power that results from that restriction would not impermissibly undermine the President's ability to perform his Article 2 functions. 1. The requirement of a clear statement to apply statutes to presidential conduct does not limit the obstruction statutes. Before addressing Article 2 issues directly, we consider one threshold statutory construction principle that is unique to the presidency: the principle that general statutes must be read as not applying to the President if they do not expressly apply where application would arguably limit the President's constitutional role. Office of Legal Counsel, Application of U.S. Code, Title 28, to Presidential Appointments of Federal Judges. Opinions of the Office of Legal Counsel, Volume 19, 1995. This clear statement rule has its source in two principles. Statutes should be construed to avoid serious constitutional questions, and Congress should not be assumed to have altered the constitutional separation of powers without clear assurance that it intended that result. Office of Legal Counsel, the constitutional separation of powers between the President and Congress. Opinions of the Office of Legal Counsel, Volume 20, 1996. The Supreme Court has applied that clear statement rule in several cases. In one leading case, the Court construed the Administrative Procedure Act, United States Code, Title 5, Section 701, not to apply to judicial review of presidential action. Franklin v. Massachusetts, United States 505, 1992. The Court explained that it would require an express statement by Congress before assuming it intended the President's performance of his statutory duties to be reviewed for abuse of discretion. In another case, the Court interpreted the word utilized in the Federal Advisory Committee Act, FACA, United States Code Title 5, to apply only to the use of advisory committees established directly or indirectly by the government, thereby excluding the American Bar Association's advice to the Department of Justice about federal judicial candidates. Public Citizen v. United States Department of Justice, U.S. 491, 1989. The court explained that a broader interpretation of the term utilized in FACA would raise serious questions whether the statute infringed unduly on the President's Article II power to nominate federal judges and violated the doctrine of separation of powers. Another case found that an established canon of statutory construction applied with special force to provisions that would impinge on the President's foreign affairs powers if construed broadly. Sale v. Haitian Centers Counsel, U.S. 155, 1993, applying the presumption against extraterritorial application to construe the Refugee Act of 1980 as not governing in an overseas context where it could affect foreign and military affairs for which the President has unique responsibility. See application of United States Code Title 28, Section 458 to presidential appointments of federal judges. Office of Legal Counsel Opinions, Volume 19, discussing Franklin, Public Citizen, and Sale. The Department of Justice has relied on this clear statement principle to interpret certain statutes as not applying to the President at all, similar to the approach taken in Franklin. See Memorandum for Richard T. Burris, Office of the President, from Lawrence H. Silberman, Deputy Attorney General, Ray, Conflict of Interest Problems Arising out of the President's Nomination of Nelson A. Rockefeller to be Vice President under the 25th Amendment to the Constitution, August 28, 1974. Criminal Conflict of Interest Statute, United States Code, Title 18, Section 208, does not apply to the President. Other OLC opinions interpret statutory text not to apply to certain presidential or executive actions because of constitutional concerns. See Application of United States Code Title 28, Section 458 to presidential appointments of federal judges. Opinions of the Office of Legal Counsel, Volume 19, Consanguinity Limitations on Court Appointments. United States Code, Title 28, Section 458, found inapplicable to presidential appointments of judges to the federal judiciary. Constraints imposed by United States Code, Title 18, Section 1913 on lobbying efforts. Opinions of the Office of Legal Counsel, Volume 13, 1989. Limitation on the use of appropriated funds for certain lobbying programs found inapplicable to certain communications by the President and executive officials. But OLC has also recognized that this clear statement rule does not apply with respect to a statute that raises no separation of powers questions were it to be applied to the President, such as the federal bribery statute, United States Code, Title 18, Section 201. Application of United States Code, Title 28, Section 458, to presidential appointments of federal judges. Opinions of the Office of Legal Counsel, Volume 19. OLC explained that application of Section 201 raises no separation of powers question, let alone a serious one, because the Constitution confers no power in the President to receive bribes. In support of that conclusion, OLC noted constitutional provisions that forbid increases in the President's compensation while in office, which is what a bribe would function to do. Citing U.S. Constitution, Article 2, Section 1, Clause 7, and the express constitutional power of Congress to impeach and convict a president for, inter alia, bribery, citing U.S. Constitution, Article 2, Section 4. Under OLC's analysis, Congress can permissibly criminalize certain obstructive conduct by the President, such as suborning perjury, intimidating witnesses, or fabricating evidence, because those prohibitions raise no separation of powers questions. See application of United States Code Title 28, Section 458 to presidential appointments of federal judges. Opinions of the Office of Legal Counsel, Volume 19. The Constitution does not authorize the President to engage in such conduct, and those actions would transgress the President's duty to take care that the laws be faithfully executed. U.S. Constitution, Article 2, Section 3. In view of those clearly permissible applications of the obstruction statutes to the President, Franklin's holding that the President is entirely excluded from a statute absent a clear statement would not apply in this context. A more limited application of a clear statement rule to exclude from the obstruction statutes only certain acts by the President, for example, removing prosecutors or ending investigations for corrupt reasons, would be difficult to implement as a matter of statutory interpretation. It is not obvious how a clear statement rule would apply to an omnibus provision like Section 1512 C.2 to exclude corruptly motivated obstructive acts only when carried out in the President's conduct of office. No statutory term could easily bear that specialized meaning. For example, the word corruptly has a well-established meaning that does not exclude exercises of official power for corrupt ends. Indeed, an established definition states that corruptly means action with an intent to secure an improper advantage inconsistent with official duty and the rights of others. Ballantyne's Law Dictionary, page 276, 3rd edition, 1969. And it would be contrary to ordinary rules of statutory construction to adopt an unconventional meaning of a statutory term only when applied to the President. See United States v. Santos, United States 553, 2008. Plurality opinion of Scalia J. Rejecting proposal to give the same word in the same statutory provision different meanings in different factual contexts. Public Citizen, United States 491, giving the term utilized in the FACA a uniform meaning to avoid constitutional questions. Nor could such an exclusion draw on a separate and established background interpretive presumption, such as the presumption against extraterritoriality applied in Sale. The principle that courts will construe a statute to avoid serious constitutional questions is not a license for the judiciary to rewrite language enacted by the legislature. Salinas v. United States, United States 522, 1997. It is one thing to acknowledge and accept well-defined or even newly enunciated, generally applicable background principles of assumed legislative intent. It is quite another to espouse the broad proposition that criminal statutes do not have to be read as broadly as they are written, but are subject to case-by-case exceptions. Brogan v. United States, U.S. 522, 1998. When a proposed construction would thus function as an extra-textual limit on a statute's compass, thereby preventing the statute from applying to a host of cases falling within its clear terms, Lauren, United States 573, it is doubtful that the construction would reflect the Congress's intent. That is particularly so with respect to obstruction statutes, which have been given a broad and all-inclusive meaning. Rainey, discussing sections 1503 and 1505. Accordingly, since no established principle of interpretation would exclude the presidential conduct we have investigated from statutes such as sections 1503, 1505, 1512b, and 1512c2, we proceed to examine the separation of powers issues that could be raised as an Article II defense to the application of those statutes. 2. Separation of powers principles support the conclusion that Congress may validly prohibit corrupt obstructive acts carried out through the President's official powers. When Congress imposes a limitation on the exercise of Article II powers, the limitation's validity depends on whether the measure disrupts the balance between the coordinate branches. Nixon v. Administrator of General Services, United States 433, 1977. Even when a branch does not arrogate power to itself, the separation of powers doctrine requires that a branch not impair an other in the performance of its constitutional duties. Loving v. United States, United States 517, 1996. The separation of powers does not mean, however, that the branches ought to have no partial agency in or no control over the acts of each other. Clinton v. Jones, United States 520, 1997, quoting James Madison, The Federalist, No. 47. In this context, a balancing test applies to assess separation of powers issues. Applying that test here, we concluded that Congress can validly make obstruction of justice statutes applicable to corruptly motivated official acts of the President without impermissibly undermining his Article II functions. A. The Supreme Court's separation of powers balancing test applies in this context. A congressionally imposed limitation on presidential action is assessed to determine the extent to which it prevents the executive branch from accomplishing its constitutionally assigned functions and, if the potential for disruption is present, whether that impact is justified by an overriding need to promote objectives within the constitutional authority of Congress. Administrator of General Services, United States 433, see Nixon v. Fitzgerald, United States 457, 1982, United States v. Nixon, United States 418, 1974. That balancing test applies to a congressional regulation of presidential power through the obstruction of justice laws. When an Article II power has not been explicitly assigned by the text of the Constitution to be within the sole province of the President, but rather was thought to be encompassed within the general grant to the President of the executive power, the Court has balanced competing constitutional considerations. Public Citizen, United States 491, Kennedy J., concurring in the judgment, joined by Rehnquist C.J. and O'Connor J. As Justice Kennedy noted in Public Citizen, the Court has applied a balancing test to restrictions on the President's power to remove executive officers, a power that is not conferred by any explicit provision in the text of the Constitution, as is the appointment power, but rather is inferred to be a necessary part of the grant of the executive power. Citing Morrison v. Olson, United States 487, 1988. and Myers v. United States, United States 272, 1926. Consistent with that statement, Morrison sustained a good cause limitation on the removal of an inferior officer with defined prosecutorial responsibilities after determining that the limitation did not impermissibly undermine the President's ability to perform his Article II functions. The Court has also evaluated other general executive power claims through a balancing test. For example, the Court evaluated the President's claim of an absolute privilege for presidential communications about his official acts by balancing that interest against the judicial branch's need for evidence in a criminal case. United States v. Nixon, supra, recognizing a qualified constitutional privilege for presidential communications on official matters. The Court has also upheld a law that provided for archival access to presidential records despite a claim of absolute presidential privilege over the records. Administrator of General Services, United States 433. The analysis in those cases supports applying a balancing test to assess the constitutionality of applying the obstruction of justice statutes to presidential exercises of executive power. Only in a few instances has the Court applied a different framework. When the President's power is both exclusive and conclusive on the issue, Congress is precluded from regulating its exercise. Zivotofsky v. Carey, Supreme Court 135, 2015. In Zivotofsky, for example, the Court followed Justice Jackson's familiar tripartite framework in Youngstown Sheet and Tube Company v. Sawyer, U.S. 343, 1952, Jackson J. concurring, and held that the President's authority to recognize foreign nations is exclusive. See also Public Citizen, United States 491. Kennedy J. concurring in the judgment, citing the power to grant pardons under U.S. Constitution Article 2, Section 2, Clause 1, and the presentment clauses for legislation, U.S. Constitution Article 1, Section 7, Clauses 2, 3 as examples of exclusive presidential powers by virtue of constitutional text. But even when a power is exclusive, Congress powers and its central role in making laws give it substantial authority regarding many of the policy determinations that precede and follow the President's act. Zivotofsky. For example, although the President's power to grant pardons is exclusive and not subject to congressional regulation, see United States v. Klein, United States 80, 1872, Congress has the authority to prohibit the corrupt use of anything of value to influence the testimony of another person in a judicial, congressional, or agency proceeding. United States Code Title 18, Section 201b3, which would include the offer or promise of a pardon to induce a person to testify falsely or not to testify at all. The offer of a pardon would precede the act of pardoning, and thus be within Congress's power to regulate, even if the pardon itself is not. Just as the Speech or Debate Clause, U.S. Constitution Article 1, Section 6, Clause 1, absolutely protects legislative acts, but not a legislator's taking or agreeing to take money for a promise to act in a certain way, for it is taking the bribe, not performance of the illicit compact, that is a criminal act. United States v. Brewster, United States 408, 1972. The promise of a pardon to corruptly influence testimony would not be a constitutionally immunized act. The application of obstruction statutes to such promises, therefore, would raise no serious separation of powers issue. B. The effect of obstruction of justice statutes on the President's capacity to perform his Article 2 responsibilities is limited. Under the Supreme Court's balancing test for analyzing separation of powers issues, the first task is to assess the degree to which applying obstruction of justice statutes to presidential actions affects the President's ability to carry out his Article 2 responsibilities. Administrator of General Services, U.S. 433. As discussed above, applying obstruction of justice statutes to presidential conduct that does not involve the President's conduct of office, such as influencing the testimony of witnesses, is constitutionally unproblematic. The President has no more right than other citizens to impede official proceedings by corruptly influencing witness testimony. The conduct would be equally improper whether effectuated through direct efforts to produce false testimony or suppress the truth, or through the actual, threatened, or promised use of official powers to achieve the same result. The President's action in curtailing criminal investigations or prosecutions, or discharging law enforcement officials raises different questions. Each type of action involves the exercise of executive discretion in furtherance of the President's duty to take care that the laws be faithfully executed. U.S. Constitution Article 2, Section 3. Congress may not supplant the President's exercise of executive power to supervise prosecutions or to remove officers who occupy law enforcement positions. See Boucher v. Simar, United States 478, 1986. Congress cannot reserve for itself the power of removal of an officer charged with the execution of the laws except by impeachment, because the structure of the Constitution does not permit Congress to execute the laws. This kind of congressional control over the execution of the laws is constitutionally impermissible. Yet, the obstruction of justice statutes do not aggrandize power in Congress or usurp executive authority. Instead, they impose a discrete limitation on conduct only when it is taken with the corrupt intent to obstruct justice. The obstruction statutes thus would restrict presidential action only by prohibiting the President from acting to obstruct official proceedings for the improper purpose of protecting his own interests. The direct effect on the President's freedom of action would correspondingly be a limited one. A preclusion of corrupt official action is not a major intrusion on Article 2 powers. For example, the proper supervision of criminal law does not demand freedom for the President to act with the intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action undertaken for such personal purposes furthers, rather than hinders, the impartial and even-handed administration of the law. And the Constitution does not mandate that the President have unfettered authority to direct investigations or prosecutions with no limits whatsoever in order to carry out his Article 2 functions. See Heckler v. Cheney, United States 470, 1985. Congress may limit an agency's exercise of enforcement power if it wishes, either by setting substantive priorities or by otherwise circumscribing an agency's power to discriminate among issues or cases it will pursue. United States v. Nixon, U.S. 418. To read the Article 2 powers of the President as providing an absolute privilege to withhold confidential information from a criminal trial would upset the constitutional balance of a workable government and gravely impair the role of the courts under Article 3. Nor must the President have unfettered authority to remove all executive branch officials involved in the execution of the laws. The Constitution establishes that Congress has legislative authority to structure the executive branch by authorizing Congress to create executive departments and officer positions and to specify how inferior officers are appointed. For example, U.S. Constitution, Article 1, Section 8, Clause 18, Necessary and Proper Clause. Article 2, Section 2, Clause 1, Opinions Clause. Article 2, Section 2, Clause 2, Appointments Clause. See Free Enterprise Fund, United States 561. While the President's removal power is an important means of ensuring that officers faithfully execute the law, Congress has recognized authority to place certain limits on removal. The President's removal powers are at their zenith with respect to principal officers, that is, officers who must be appointed by the President and who report to him directly. See Free Enterprise Fund, U.S. 561. The President's exclusive and illimitable power of removal of those principal officers furthers the President's ability to ensure that the laws are faithfully executed. Myers, U.S. 272. Thus, there are some purely executive officials who must be removable by the President at will if he is to be able to accomplish his constitutional role. Morrison, U.S. 487. Myers, U.S. 272. The President's cabinet officers must do his will, and the moment that he loses confidence in the intelligence, ability, judgment, or loyalty of any one of them, he must have the power to remove him without delay. Humphrey's Executor v. United States, U.S. 295, 1935. Congress has the power to create independent agencies headed by principal officers, removable only for good cause. In light of those constitutional precedents, it may be that the obstruction statutes could not be constitutionally applied to limit the removal of a cabinet officer, such as the Attorney General. See United States Code Title 5, Section 101, United States Code Title 28, Section 503. In that context, at least absent circumstances showing that the President was clearly attempting to thwart accountability for personal conduct while evading ordinary political checks and balances, even the highly limited regulation imposed by the obstruction statutes could possibly intrude too deeply on the President's freedom to select and supervise members of his cabinet. The removal of inferior officers, in contrast, need not necessarily be at will for the President to fulfill his constitutionally assigned role in managing the executive branch. Inferior officers are officers whose work is directed and supervised at some level by other officers appointed by the President with the Senate's consent. Free Enterprise Fund, U.S. 561. Quoting Edmund v. United States, U.S. 520, 1997. The Supreme Court has long recognized Congress's authority to place for-cause limitations on the President's removal of inferior officers whose appointment may be vested in the head of a department. U.S. Constitution Article 2, Section 2, Clause 2. See United States v. Perkins, U.S. 116, 1886. The constitutional authority in Congress to thus vest the appointment of inferior officers in the heads of departments implies authority to limit, restrict, and regulate the removal by such laws as Congress may enact in relation to the officers so appointed. Quoting lower court decision. Morrison, U.S. 487, citing Perkins. Scalia J. dissenting, recognizing that Perkins is established law. See also Free Enterprise Fund, U.S. 561, citing Perkins and Morrison. The category of inferior officers includes both the FBI director and the special counsel, each of whom reports to the Attorney General. See United States Code Title 28, Section 509. Their work is thus directed and supervised by a presidentially appointed, Senate-confirmed officer. See In re Grand Jury Investigation. D.C. Circuit Court, February 26, 2019, holding that the special counsel is an inferior officer for constitutional purposes. Where the Constitution permits Congress to impose a good cause limitation on the removal of an executive branch officer, the Constitution should equally permit Congress to bar removal for the corrupt purpose of obstructing justice. Limiting the range of permissible reasons for removal to exclude a corrupt purpose imposes a lesser restraint on the President than requiring an affirmative showing of good cause. It follows that for such inferior officers, Congress may constitutionally restrict the President's removal authority if that authority was exercised for the corrupt purpose of obstructing justice. And even if a particular inferior officer's position might be of such importance to the execution of the laws that the President must have at-will removal authority, the obstruction of justice statutes could still be constitutionally applied to forbid removal for a corrupt reason. A narrow and discreet limitation on removal that precluded corrupt action would leave ample room for all other considerations, including disagreement over policy or loss of confidence in the officer's judgment or commitment. A corrupt purpose prohibition, therefore, would not undermine the President's ability to perform his Article II functions. Accordingly, because the separation of powers question is whether the removal restrictions are of such a nature that they impede the President's ability to perform his constitutional duty, Morrison, U.S. 487, a restriction on removing an inferior officer for a corrupt reason, a reason grounded in achieving personal rather than official ends, does not seriously hinder the President's performance of his duties. The President retains broad latitude to supervise investigations and remove officials, circumscribed in this context only by the requirement that he not act for corrupt personal purposes. C. Congress has power to protect congressional, grand jury, and judicial proceedings against corrupt acts from any source. Where a law imposes a burden on the President's performance of Article II functions, separation of powers analysis considers whether the statutory measure is justified by an overriding need to promote objectives within the constitutional authority of Congress. Administrator of General Services, U.S. 433. Here, Congress enacted the obstruction of justice statutes to protect, among other things, the integrity of its own proceedings, grand jury investigations, and federal criminal trials. Those objectives are within Congress's authority and serve strong governmental interests. 1. Congress has Article I authority to define generally applicable criminal law and apply it to all persons, including the President. Congress clearly has authority to protect its own legislative functions against corrupt efforts designed to impede legitimate fact-gathering and law-making efforts. See Watkins v. United States, U.S. 354, 1957, Chapman v. United States, D.C. Appeals Court, 5, 1895. Congress also has authority to establish a system of federal courts, which includes the power to protect the judiciary against obstructive acts. See U.S. Constitution, Article I, Section 8, Clause 9, 18. The Congress shall have the power to constitute tribunals inferior to the Supreme Court and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. The long lineage of the obstruction of justice statutes, which can be traced to at least 1831, attests to the necessity for that protection. See an act declaratory of the law concerning contempts of court, Statute, Section 4, 1831, making it a crime if any person or persons shall corruptly endeavor to influence, intimidate, or impede any juror, witness, or officer in any court of the United States in the discharge of his duty, or shall corruptly obstruct or impede, or endeavor to obstruct or impede the due administration of justice therein. 2. The Article 3 courts have an equally strong interest in being protected against obstructive acts, whatever their source. As the Supreme Court explained in United States v. Nixon, a primary constitutional duty of the judicial branch is to do justice in criminal prosecutions. In Nixon, the court rejected the president's claim of absolute executive privilege because the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantee of due process of law and gravely impair the basic function of the courts. As Nixon illustrates, the need to safeguard judicial integrity is a compelling constitutional interest, noting that the denial of full disclosure of the facts surrounding relevant presidential communications threatens the very integrity of the judicial system and public confidence in the system. 3. Finally, the grand jury cannot achieve its constitutional purpose absent protection from corrupt acts. Serious federal criminal charges generally reach the Article 3 courts based on an indictment issued by a grand jury. Cobbledick v. United States, U.S. 309, 1940. The Constitution itself makes the grand jury a part of the judicial process, and the grand jury's function is enshrined in the Fifth Amendment. U.S. Constitution, Amendment 5. No person shall be held to answer for a serious crime unless on a presentment or indictment of a grand jury. The whole theory of the grand jury's function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. United States v. Williams, U.S. 504, 1992. Pledged to indict no one because of prejudice and to free no one because of special favor. Costello v. United States, U.S. 350, 1956. If the grand jury were not protected against corrupt interference from all persons, its function as an independent charging body would be thwarted, and an impartial grand jury investigation to determine whether probable cause exists to indict is vital to the criminal justice process. The final step in the constitutional balancing process is to assess whether the separation of powers doctrine permits Congress to take action within its constitutional authority, notwithstanding the potential impact on Article 2 functions. See Administrator of General Services, U.S. 433. See also Morrison, U.S. 487. United States v. Nixon, U.S. 418. In the case of the obstruction of justice statutes, our assessment of the weighing of interest leads us to conclude that Congress has the authority to impose the limited restrictions contained in those statutes on the President's official conduct to protect the integrity of important functions of other branches of government. A general ban on corrupt action does not unduly intrude on the President's responsibility to take care that the laws be faithfully executed. U.S. Constitution Article 2, Section 3. To the contrary, the concept of faithful execution connotes the use of power in the interest of the public, not in the office holder's personal interests. See I. Samuel Johnson, A Dictionary of the English Language, 1755, page 763, Faithfully, Definition 3. With strict adherence to duty and allegiance, and immunizing the President from the generally applicable criminal prohibition against corrupt obstruction of official proceedings, would seriously impair Congress's power to enact laws to promote objectives within its constitutional authority. Administrator of General Services, U.S. 433, i.e., protecting the integrity of its own proceedings and the proceedings of Article III courts and grand juries. Accordingly, based on the analysis above, we were not persuaded by the argument that the President has blanket constitutional immunity to engage in acts that would corruptly obstruct justice through the exercise of otherwise valid Article II powers. 3. Ascertaining whether the President violated the obstruction statutes would not chill his performance of his Article II duties. Applying the obstruction statutes to the President's official conduct would involve determining as a factual matter whether he engaged in an obstructive act, whether the act had a nexus to official proceedings, and whether he was motivated by corrupt intent. But applying those standards to the President's official conduct should not hinder his ability to perform his Article II duties. Nixon v. Fitzgerald, U.S. 457, taking into account chilling effect on the President in adopting a constitutional role of presidential immunity from private civil damages action based on official duties. Several safeguards would prevent a chilling effect: the existence of settled legal standards, the presumption of regularity in prosecutorial actions, and the existence of evidentiary limitations on probing the President's motives. And historical experience confirms that no impermissible chill should exist. A. As an initial matter, the term corruptly sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. Ballantyne's Law Dictionary, 3rd edition, 1969, page 276. See United States v. Pasha, D.C. Circuit Court, 2015. Aguilar, U.S. 515, Scalia J. concurring in part and dissenting in part. That standard parallels the President's constitutional obligation to ensure the faithful execution of the laws. And virtually everything that the President does in the routine conduct of office will have a clear governmental purpose and will not be contrary to his official duty. Accordingly, the President has no reason to be chilled in those actions because, in virtually all instances, there will be no credible basis for suspecting a corrupt personal motive. That point is illustrated by examples of conduct that would and would not satisfy the stringent corrupt motive standard. Direct or indirect action by the President to end a criminal investigation into his own or his family members' conduct to protect against personal embarrassment or legal liability would constitute a core example of corruptly motivated conduct. So, too, would action to halt an enforcement proceeding that directly and adversely affected the President's financial interests for the purpose of protecting those interests. In those examples, official power is being used for the purpose of protecting the President's personal interests. In contrast, the President's actions to serve political or policy interests would not qualify as corrupt. The President's role as head of the government necessarily requires him to take into account political factors in making policy decisions that affect law enforcement actions and proceedings. For instance, the President's decision to curtail a law enforcement investigation to avoid international friction would not implicate the obstruction of justice statutes. The criminal law does not seek to regulate the consideration of such political or policy factors in the conduct of government. And when legitimate interests animate the President's conduct, those interests will almost invariably be readily identifiable based on objective factors. Because the President's conduct in those instances will obviously fall outside the zone of obstruction law, no chilling concern should arise. B. There is also no reason to believe that investigations, let alone prosecutions, would occur except in highly unusual circumstances, when a credible factual basis exists to believe that obstruction occurred. prosecutorial action enjoys a presumption of regularity. Absent clear evidence to the contrary, courts presume that prosecutors have properly discharged their official duties. Armstrong, U.S. 517, quoting United States v. Chemical Foundation, Inc., United States 272, 1926. The presumption of prosecutorial regularity would provide even greater protection to the President than exists in routine cases given the prominence and sensitivity of any matter involving the President, and the likelihood that such matters will be subject to thorough and careful review at the most senior levels of the Department of Justice. Under OLC's opinion that a sitting President is entitled to immunity from indictment, only a successor administration would be able to prosecute a former President. But that consideration does not suggest that a President would have any basis for fearing abusive investigations or prosecutions after leaving office. There are obvious political checks against initiating a baseless investigation or prosecution of a former President. See Administrator of General Services, United States 433, Considering Political Checks in Separation of Powers Analysis. And the Attorney General holds the power to conduct the criminal litigation of the United States government. United States v. Nixon, U.S. 418, citing United States Code Title 28, Section 516, which provides a strong institutional safeguard against politicized investigations or prosecutions. These considerations distinguish the Supreme Court's holding in Nixon v. Fitzgerald that, in part because inquiries into the President's motives would be highly intrusive, the President is absolutely immune from private civil damages actions based on his official conduct. U.S. 457. As Fitzgerald recognized, there is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions. Fitzgerald, United States 457. C. Cheney, United States 542. And private actions are not subject to the institutional protections of an action under the supervision of the Attorney General, and subject to a presumption of regularity. Armstrong, United States 517. C. In the rare cases in which a substantial and credible basis justifies conducting an investigation of the President, the process of examining his motivations to determine whether he acted for a corrupt purpose need not have a chilling effect. Ascertaining the President's motivations would turn on any explanation he provided to justify his actions, the advice he received, the circumstances surrounding the actions, and the regularity or irregularity of the process he employed to make decisions. But grand juries and courts would not have automatic access to confidential presidential communications on those matters. Rather, they could be presented in official proceedings only on a showing of sufficient need. Nixon, United States 418. In re, sealed case. D.C. Circuit, 1997. See also Administrator of General Services, United States 433. Former President can invoke presidential communications privilege, although successor's failure to support the claim detracts from its weight. In any event, probing the President's intent in a criminal matter is unquestionably constitutional in at least one context. The offense of bribery turns on the corrupt intent to receive a thing of value in return for being influenced in official action. United States Code Title 18, Section 201, subsection B, 2. There can be no serious argument against the president's potential criminal liability for bribery offenses, notwithstanding the need to ascertain his purpose and intent. See U.S. Constitution, Article 1, Section 3, Article 2, Section 4. See also Application of United States Code, Title 28, Section 458, to presidential appointments of federal judges. Opinions of the Office of Legal Counsel, Volume 19. Application of Section 201 to the President raises no separation of powers issue, let alone a serious one. D. Finally, history provides no reason to believe that any asserted chilling effect justifies exempting the President from the obstruction laws. As a historical matter, presidents have very seldom been the subjects of grand jury investigations, and it is rarer still for circumstances to raise even the possibility of a corrupt personal motive for arguably obstructive action through the president's use of official power. Accordingly, the president's conduct of office should not be chilled based on hypothetical concerns about the possible application of a corrupt motive standard in this context. In sum, contrary to the position taken by the President's Counsel, we concluded that, in light of the Supreme Court precedent governing separation of powers issues, we had a valid basis for investigating the conduct at issue in this report. In our view, the application of the obstruction statutes would not impermissibly burden the President's performance of his Article II function to supervise prosecutorial conduct or to remove inferior law enforcement officers. And the protection of the criminal justice system from corrupt acts by any person, including the President, accords with the fundamental principle of our government that no person in this country is so high that he is above the law. United States v. Lee, U.S. 106, 1882. See also Clinton v. Jones, U.S. 520, United States v. Nixon, Supra. End of Section 21. Recording by ljarrow.
Section 22 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kathleen Nelson. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller, Section 22. 4. Conclusion. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the President's conduct. The evidence we obtained about the President's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the President committed a crime, it also does not exonerate him. End of Section 22.
Section 23 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information, or to volunteer, please visit LibriVox.org. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller. Appendix A. Order appointing special counsel. Office of the Deputy Attorney General, Washington, D.C. 20530. Order number 3915-2017. Appointment of special counsel to investigate Russian interference with the 2016 presidential election and related matters. By virtue of the authority vested in me as Acting Attorney General, including Title 28, United States Code Sections 509, 510, and 515, in order to discharge my responsibility to provide supervision and management of the Department of Justice, and to ensure a full and thorough investigation of the Russian government's efforts to interfere in the 2016 presidential election, I hereby order as follows. A. Robert S. Mueller III is appointed to serve as special counsel for the United States Department of Justice. B. The special counsel is authorized to conduct the investigation confirmed by then FBI Director James B. Comey in testimony before the House Permanent Select Committee on Intelligence on March 20th, 2017, including 1. Any links and/or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, and 2. Any matters that arose or may arise directly from the investigation, and 3. Any other matters within the scope of Title 28, Code of Federal Regulations, Section 600.4, Subsection A. C. If the special counsel believes it is necessary and appropriate, the special counsel is authorized to prosecute federal crimes arising from the investigation of these matters. D. Sections 600.4 through 600.10 of Title 28 of the Code of Federal Regulations are applicable to the special counsel. May 17th, 2017. Rod J. Rosenstein, Acting Attorney General. End of Section 23.
Section 24, Appendix B, Glossary of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller, Section 24. Appendix B, Glossary. The following glossary contains names and brief descriptions of individuals and entities referenced in the 2 volumes of this report. It is not intended to be comprehensive and is intended only to assist a reader in reading the rest of the report. Referenced persons: Agalarov Aras, Russian real estate developer, owner of the Crocus Group, met Donald Trump in connection with the Miss Universe pageant and helped arrange the June 9, 2016 meeting at Trump Tower between Natalia Veselnitskaya and Trump campaign officials. Agalarov Emin, performer, executive vice president of Crocus Group and son of Aras Agalarov, helped arrange the June 9, 2016 meeting at Trump Tower between Natalia Veselnitskaya and Trump campaign officials. Akhmetov Rinat, former member in the Ukrainian parliament who hired Paul Manafort to to conduct work for Ukrainian political party, the Party of Regions. Akhmetchin, Rinat, U.S. lobbyist and associate of Natalia Veselnitskaya, who attended the June 9, 2016 meeting at Trump Tower between Veselnitskaya and Trump campaign officials. Aslanov, J. Kuhn, J., head of U.S. Department of the Internet Research Agency, which engaged in an active measures social media campaign to interfere in the 2016 U.S. presidential election. Assange, Julian, founder of WikiLeaks, which in 2016 posted on the Internet documents stolen from entities and individuals affiliated with the Democratic Party. Avan, Pyotr, chairman of the board of Alpha Bank, who attempted outreach to the presidential transition team in connection with anticipated post-election sanctions. Bannon, Stephen, Steve, White House chief strategist and senior counselor to President Trump, January 2017 to August 2017. Chief executive of the Trump campaign. Baranov, Andrei, Director of Investor Relations at Russian state-owned oil company Rosneft and associate of Carter Page. Berkowitz, Avi, assistant to Jared Kushner. Bente, Dana, Acting Attorney General, January 2017 to February 2017, Acting Deputy Attorney General, February 2017 to April 2017. Bogacheva, Anna, Internet Research Agency employee who worked on Active Measures social media campaign to interfere in the 2016 U.S. presidential election, traveled to the United States under false pretenses in 2014. Bossert, Thomas, Tom, former Homeland Security Advisor to the President, who also served as a senior official on the presidential transition team. Boyarkin, Viktor, employee of Russian oligarch Oleg Deripaska. Boyd, Charles, chairman of the board of directors at the Center for the National Interest, a U.S.-based think tank with operations in and connections to Russia. Boyko, Yuri, member of the Ukrainian political party Opposition Bloc and member of the Ukrainian parliament. Brand, Rachel, Associate Attorney General, May 2017 to February 2018. Browder, William, Bill, founder of Hermitage Capital Management, who lobbied in favor of the Magnitsky Act, which imposed financial and travel sanctions on Russian officials. Bulyatov, Alexander, Russian intelligence official who associated with Carter Page in 2008. Burchik, Mikhail, Executive Director of the Internet Research Agency, which engaged in an active measures social media campaign to interfere in the 2016 U.S. presidential election. Burke, William, personal attorney to Don McGahn, White House counsel. Burnham, James, attorney in the White House counsel's office, who attended January 2017 meetings between Sally Yates and Donald McGahn. Burt, Richard, former U.S. ambassador who had done work for Alpha Bank and was a board member of the Center for the National Interest. Bistrov, Mikhail, general director of the Internet Research Agency, which engaged in an active measures social media campaign to interfere in the 2016 U.S. presidential election. Calamari, Matt, Chief Operating Officer for the Trump Organization. Caputo, Michael, Trump Campaign Advisor. Chaika, Yuri, Prosecutor General of the Russian Federation, who also maintained a relationship with Aris Agalarov. Christie, Chris, former Governor of New Jersey. Clapper, James, Director of National Intelligence, August 2010 to January 2017. Clovis, Samuel Jr., Chief Policy Advisor and National Co-Chair of the Trump campaign. Coates, Dan, Director of National Intelligence. Cobb, Ty, Special Counsel to the President, July 2017 to May 2018. Cohen, Michael, former Vice President to the Trump Organization and Special Counsel to Donald Trump, who spearheaded an effort to build a Trump-branded property in Moscow. He admitted to lying to Congress about the project. Comey, James Jr., Director of the Federal Bureau of Investigation, September 4, 2013 to May 9, 2017. Conway, Kellyanne, Counselor to President Trump and Manager of the Trump campaign. Corallo, Mark, Spokesman for President Trump's personal legal team, June 2017 to July 2017. Corsi, Jerome, author and political commentator who formerly worked for WorldNet Daily and InfoWars. Redaction: harm to ongoing matter. Costello, Robert, attorney who represented he had a close relationship with Rudolph Giuliani, the president's personal counsel. Credico, Randolph, Randy, radio talk show host who interviewed Julian Assange in 2016. Redaction: harm to ongoing matter. Davis, Richard, Rick, Jr., partner with Pegasus Sustainable Century Merchant Bank, business partner of Paul Manafort, and co-founder of the Davis Manafort lobbying firm. Dearborn, Rick, former White House Deputy Chief of Staff for Policy, who previously served as Chief of Staff to Senator Jeff Sessions. Dempsey, Michael, Office of Director of National Intelligence official, who recalled discussions with Dan Coates after Coates' meeting with President Trump on March 22, 2017. Denman, Diana, delegate to 2016 Republican National Convention, who proposed a platform plank amendment that included armed support for Ukraine. Deripaska, Oleg, Russian businessman with ties to Vladimir Putin, who hired Paul Manafort for consulting work between 2005 and 2009. Dilan Uttam, attorney in the White House counsel's office, January 2017 to June 2018. Dmitriev, Kirill, head of the Russian Direct Investment Fund, met with Eric Prince in the Seychelles in January 2017, and separately drafted a U.S.-Russia reconciliation plan with Rick Gerson. Donaldson, Annie, Chief of Staff to White House Counsel Donald McGahn, January 2017 to December 2018. Dvorkovich, Arkady, Deputy Prime Minister of the Russian Federation and Chairman of the Board of Directors of the New Economic School in Moscow. He met with Carter Page twice in 2016. Dvoskin, Yevgeny, Executive of GenBank in Crimea and Associate of Felix Sater. Eisenberg, John, attorney in the White House Counsel's Office and legal counsel for the National Security Council. Erkova, Lana, a.k.a. Lana Alexander, ex-wife of Dmitry Klokov, who emailed Ivanka Trump to introduce Klokov to the Trump campaign in the fall of 2015. Fabrizio, Anthony, Tony, partner at the research and consulting firm Fabrizio, Lee & Associates. He was a pollster for the Trump campaign and worked with Paul Manafort on Ukraine-related polling after the election. Fishbein, Jason, attorney who performed work for Julian Assange and also sent WikiLeaks a password for an unlaunched website, putintrump.org, on September 20, 2016. Flynn Michael G., a.k.a. Michael Flynn Jr., son of Michael T. Flynn, National Security Advisor, January 20, 2017 to February 13, 2017. Flynn, Michael T., National Security Advisor, January 20, 2017 to February 13, 2017. Director of the Defense Intelligence Agency, July 2012 to August 7, 2014, and Trump Campaign Advisor. He pleaded guilty to lying to the FBI about communications with Ambassador Sergei Kislyak in December 2016. Forestman Robert, Bob. Investment banker who sought meetings with the Trump campaign in spring 2016 to discuss Russian foreign policy and after the election met with Michael Flynn. Futerfas, Alan. Outside counsel for the Trump Organization and subsequently personal counsel for Donald Trump Jr. Garden, Alan. General Counsel of the Trump Organization. Gates, Richard Rick III. Deputy Campaign Manager for Trump Campaign, Trump Inaugural Committee Deputy Chairman, and longtime employee of Paul Manafort. He pleaded guilty to conspiring to defraud the United States and violate U.S. laws, as well as making false statements to the FBI. Gerson, Richard Rick. New York hedge fund manager and associate of Jared Kushner. During the transition period, he worked with Kirill Dmitriev on a proposal for reconciliation between the United States and Russia. Gistaro, Edward. Deputy Director of National Intelligence for Intelligence Integration. Glassner, Michael. Political Director of the Trump campaign, who helped introduce George Papadopoulos to others in the Trump campaign. Goldstone, Robert. Publicist for Emis Agalarov, who contacted Donald Trump Jr. to arrange the June 9, 2016 meeting at Trump Tower between Natalia Veselnitskaya and Trump campaign officials. Gordon, Jeffrey, J.D. National Security Advisor to the Trump campaign involved in changes to the Republican Party platform and who communicated with Russian Ambassador Sergei Kislyak at the Republican National Convention. Gorkov, Sergei. Chairman of Vneshekonombank, VEB, a Russian state-owned bank, who met with Jared Kushner during the transition period. Graf, Rona. Senior Vice President and Executive Assistant to Donald J. Trump at the Trump Organization. Entry redacted. Harm to ongoing matter. Hawker, Jonathan. Public Relations Consultant at FTI Consulting. Worked with Davis Manafort International LLC on public relations campaign in Ukraine. Heilbrunn, Jacob. Editor of The National Interest, the periodical that officially hosted candidate Trump's April 2016 foreign policy speech. Hicks, Hope. White House Communications Director, August 2017 to March 2018, and Press Secretary for the Trump campaign. Holt, Lester. NBC News anchor who interviewed President Trump on May 11, 2017. Hunt, Jody. Chief of Staff to Attorney General Jeff Sessions, February 2017 to October 2017. Ivanov, Igor. President of the Russian International Affairs Council and former Russian Foreign Minister. Ivan Timofeyev told George Papadopoulos that Ivanov advised on arranging a Moscow visit for the Trump campaign. Ivanov Sergei, Special Representative of Vladimir Putin, former Russian Deputy Prime Minister and former FSB Deputy Director. In January 2016, Michael Cohen emailed the Kremlin requesting to speak to Ivanov. Kasowitz, Mark. President Trump's personal counsel, May 2017 to July 2017. Katsev, Denis. Son of Peter Katsev, owner of Russian company Prevazon Holdings Limited, and associate of Natalia Veselnitskaya. Katsev, Peter. Russian businessman and father of Denis Katsev. Entry redacted. Harm to ongoing matter. Kavaladze, Irakli, Ike. Vice President at Crocus Group and Aris Agalarov's deputy in the United States. He participated in the June 9, 2016 meeting at Trump Tower between Natalia Veselnitskaya and Trump campaign officials. Kaverzina, Irina. Employee of the Internet Research Agency, which engaged in an active measures social media campaign to interfere in the 2016 U.S. presidential election. Kelly, John. White House Chief of Staff, July 2017 to January 2019. Khalil Zad, Zelmay. U.S. Special Representative to Afghanistan and former U.S. Ambassador. He met with Senator Jeff Sessions during foreign policy dinners put together through the Center for the National Interest. Kilimnik, Konstantin. Russian-Ukrainian political consultant and longtime employee of Paul Manafort, assessed by the FBI to have ties to Russian intelligence. Kislyak, Sergei. Former Russian ambassador to the United States and current Russian senator from Mordovia. Klementov, Denis. Employee of the New Economic School who informed high-ranking Russian government officials of Carter Page's July 2016 visit to Moscow. Klementov, Dmitry. Brother of Denis Klementov, who contacted Kremlin Press Secretary Dmitry Peskov about Carter Page's July 2016 visit to Moscow. Klokov, Dmitry. Executive for PJSC Federal Grid Company of Unified Energy System and former aide to Russia's Minister of Energy. He communicated with Michael Cohen about a possible meeting between Vladimir Putin and candidate Trump. Kobyakov, Anton. Advisor to Vladimir Putin, a member of the Rose Congress Foundation, who invited candidate Trump to the St. Petersburg International Economic Forum. Krikovich, Andrei. Professor at the Higher School of Economics, who recommended that Carter Page give a July 2016 commencement address in Moscow. Krylova, Alexandra. Internet Research Agency employee who worked on Active Measures social media campaign to interfere in the 2016 U.S. presidential election. Traveled to the United States under false pretenses in 2014. Kushner, Jared. President Trump's son-in-law and senior advisor to the president. Kuznetsov, Sergei. Russian government official at the Russian Embassy to the United States, who transmitted Vladimir Putin's congratulations to President-elect Trump for his electoral victory on November 9, 2016. Landrum, Pete. Advisor to Senator Jeff Sessions, who attended the September 2016 meeting between Sessions and Russian Ambassador Sergei Kislyak. Lavrov, Sergei. Russian Minister of Foreign Affairs and former permanent representative of Russia to the United Nations. Ledeen, Barbara. Senate staffer and associate of Michael Flynn, who sought to obtain Hillary Clinton emails during the 2016 U.S. presidential campaign period. Ledeen, Michael. Member of the Presidential Transition Team who advised on foreign policy and national security matters. Leggett, Richard. Deputy Director of the National Security Agency, January 2014 to April 2017. Present when President Trump called Michael Rogers on March 26, 2017. Lewandowski, Corey. Campaign Manager for the Trump campaign, January 2015 to June 2016. Luff, Sandra. Legislative Director for Senator Jeff Sessions. Attended a September 2016 meeting between Sessions and Russian Ambassador Sergei Kislyak. Lyovochkin, Serhiy. Member of Ukrainian Parliament and member of Ukrainian Political Party, Opposition Bloc Party. Magnitsky, Sergei. Russian tax specialist who alleged Russian government corruption and died in Russian police custody in 2009. His death prompted passage of the Magnitsky Act, which imposed financial and travel sanctions on Russian officials. Malik, Theodore Ted, Chief Executive Officer of Global Fiduciary Governance and the Roosevelt Group. He was a London-based associate of Jerome Corsi. Manafort, Paul Jr., Trump campaign member, March 2016 to August 2016, and Chairman and Chief Strategist, May 2016 to August 2016. Mashburn, John, Trump administration official and former policy director to the Trump campaign. McCabe, Andrew, acting director of the FBI, May 2017 to August 2017, deputy director of the FBI, February 2016 to January 2018. McCord, Mary, acting assistant attorney general, October 2016 to May 2017. McFarland, KT, deputy White House National Security Advisor, January 2017 to May 2017. McGann, Donald, Don, White House Counsel, January 2017 to October 2018. Medvedev, Dmitry, Prime Minister of Russia. Melnik, Yuri, spokesperson for the Russian Embassy in Washington, D.C., who connected with George Papadopoulos on social media. Mifsud, Joseph, Maltese national and former London-based professor who, immediately after returning from Moscow in April 2016, told George Papadopoulos that the Russians had dirt in the form of thousands of Clinton emails. Miller, Matt, Trump campaign staff member who was present at the meeting of the National Security and Defense Platform Subcommittee in July 2016. Miller, Stephen, senior advisor to the president. Milyan, Sergei, founder of the Russian-American Chamber of Commerce, who met with George Papadopoulos during the campaign. Mnuchin, Stephen, Secretary of the Treasury. Entry redacted, harm to ongoing matter. Muller-Magoon, Andrew, member of Hacker Association, Chaos Computer Club, and associate of Julian Assange, founder of WikiLeaks. Nader, George, advisor to the United Arab Emirates Crown Prince, who arranged a meeting between Kirill Dmitriev and Eric Prince during the transition period. Natiksha, Victor, Russian military officer in command of a unit involved in Russian hack and release operations to interfere in the 2016 U.S. presidential election. Oganov, Georgy, advisor to Oleg Deripaska and a board member of investment company Basic Element. He met with Paul Manafort in Spain in early 2017. Okniansky, Henry, a.k.a. Henry Greenberg, Florida-based Russian individual who claimed to have derogatory information pertaining to Hillary Clinton. He met with Roger Stone in May 2016. Page, Carter, foreign policy advisor to the Trump campaign, who advocated pro-Russian views and made July 2016 and December 2016 visits to Moscow. Papadopoulos, George, foreign policy advisor to the Trump campaign, who received information from Joseph Mifsud that the Russians had dirt in the form of thousands of Clinton emails. He pleaded guilty to lying to the FBI about his contact with Mifsud. Parscale, Bradley, digital media director for the 2016 Trump campaign. Patton, William, Sam, Jr., lobbyist and business partner of Konstantin Kalimnik. Peskov, Dmitry, deputy chief of staff of and press secretary for the Russian presidential administration. Faraz, Walid, foreign policy advisor to the Trump campaign and co-secretary general of the Transatlantic Parliamentary Group on Counterterrorism, TAG. Pinedo, Richard, U.S. person who pleaded guilty to a single-count information of identity fraud. Podesta, John Jr., Clinton campaign chairman whose email account was hacked by the GRU. WikiLeaks released his stolen emails during the 2016 campaign. Podobny, Victor, Russian intelligence officer who interacted with Carter Page while operating inside the United States, later charged in 2015 with conspiring to act as an unregistered agent of Russia. Polyakova, Elena, personal assistant to Dmitry Peskov, who responded to Michael Cohen's outreach about the Trump Tower Moscow project in January 2016. Polonskaya, Olga, Russian national introduced to George Papadopoulos by Joseph Mifsud as an individual with connections to Vladimir Putin. Pompeo, Michael, U.S. Secretary of State, Director of the Central Intelligence Agency, January 2017 to April 2018. Porter, Robert, White House Staff Secretary, January 2017 to February 2018. Priebus, Reince, White House Chief of Staff, January 2017 to July 2017, Chair of the Republican National Committee, January 2011 to January 2017. Prigozhin, Yevgeny, head of Russian companies Concord Catering and Concord Management and Consulting, supported and financed the Internet Research Agency, which engaged in an active measures social media campaign to interfere in the 2016 U.S. presidential election. Prihodka, Sergei, first deputy head of the Russian Government Office and former Russian deputy prime minister. In January 2016, he invited candidate Trump to the St. Petersburg International Economic Forum. Prince, Eric, businessman and Trump campaign supporter who met with presidential transition team officials after the election and traveled to the Seychelles to meet with Kirill Dmitriev in January 2017. Rafael, Josh, White House Communications Advisor, April 2017 to February 2018. Racine, Alexei, Ukrainian associate of Henry Okniansky, who claimed to possess derogatory information regarding Hillary Clinton. Rogers, Michael, Director of the National Security Agency, April 2014 to May 2018. Rosenstein, Rod, Deputy Attorney General, April 2017 to present, Acting Attorney General for the Russian Election Interference Investigation, May 2017 to November 2018. Rozoff, Andrei, Chairman of IC Expert Investment Company, a Russian real estate development corporation that signed a letter of intent for the Trump Tower Moscow project in 2015. Ritskaladze, Yorgi, executive of the Silk Road Transatlantic Alliance, LLC, who communicated with Cohen about a Trump Tower Moscow proposal. Ruddy, Christopher, Chief Executive of Newsmax Media and Associate of President Trump. Rabicki, James, FBI Chief of Staff, May 2015 to February 2018. Samochornov, Anatoly, translator who worked with Natalia Veselnitskaya and attended a June 9, 2016 meeting at Trump Tower between Veselnitskaya and Trump campaign officials. Sanders, Sarah Huckabee, White House Press Secretary, July 2017 to present. Sater, Felix, real estate advisor who worked with Michael Cohen to pursue a Trump Tower Moscow project. Saunders, Paul J., executive with the Center for the National Interest, who worked on outlines and logistics of candidate Trump's April 2016 foreign policy speech. Sechin, Igor, executive chairman of Rosneft, a Russian state-owned oil company. Sessions, Jefferson III, Jeff, Attorney General, February 2017 to November 2018. U.S. Senator, January 1997 to February 2017. Head of the Trump campaign's Foreign Policy Advisory Team. Shoigu, Sergei, Russian Minister of Defense. Simas, Dmitry, President and Chief Executive Officer of the Center for the National Interest. Smith, Peter, investment banker, active in Republican politics, who sought to obtain Hillary Clinton emails during the 2016 U.S. presidential campaign period. Spicer, Sean, White House Press Secretary and Communications Director, January 2017 to July 2017. Stone, Roger, Advisor to the Trump campaign. Redaction, harm to ongoing matter. Tillerson, Rex, U.S. Secretary of State, February 2017 to March 2018. Timofeyev, Ivan, Director of Programs at the Russian International Affairs Council and Program Director of the Valdai Discussion Club, who communicated in 2016 with George Papadopoulos, attempting to arrange a meeting between the Russian government and the Trump campaign. Trump, Donald Jr., President Trump's son, trustee and executive vice president of the Trump Organization, helped arrange and attended the June 9, 2016 meeting at Trump Tower between Natalia Veselnitskaya and Trump campaign officials. Trump, Eric, President Trump's son, trustee and executive vice president of the Trump Organization. Trump, Ivanka, President Trump's daughter, advisor to the president and former executive vice president of the Trump Organization. Ushakov, Yuri Viktorovich, aide to Vladimir Putin and former Russian ambassador to the United States, identified to the presidential transition team as the proposed channel to the Russian government. Vino, Anton, Chief of Staff to Russian President Vladimir Putin. Vanderswan, Alexander, former attorney at Skadden Arps Slate Meagher and Flom LLP, worked with Paul Manafort and Rick Gates. Vargas, Catherine, executive assistant to Jared Kushner. Vasilchenko, Gleb, Internet Research Agency employee who engaged in an active measures social media campaign to interfere in the 2016 U.S. presidential election. Veselnitskaya, Natalia, Russian attorney who advocated for the repeal of the Magnitsky Act and was the principal speaker at the June 9, 2016 meeting at Trump Tower with Trump campaign officials. Weber, Shlomo, rector of the New Economic School, NES, in Moscow, who invited Carter Page to speak at NES commencement in July 2016. Yanukovych, Viktor, former president of Ukraine, who had worked with Paul Manafort. Yates, Sally, acting Attorney General, January 20, 2017 to January 30, 2017. Deputy Attorney General, January 10, 2015 to January 30, 2017. Yatsenko, Sergei, Deputy Chief Financial Officer of Gazprom, a Russian state-owned energy company and associate of Carter Page. Zakharova, Maria, Director of the Russian Ministry of Foreign Affairs Information and Press Department, who received notification of Carter Page's speech in July 2016 from Denis Klementov. Zayed Al Nahyan, Mohammed bin, Crown Prince of Abu Dhabi and Deputy Supreme Commander of the United Arab Emirates, UAE, Armed Forces. Entities and organizations. Alfa Bank, Russia's largest commercial bank, which is headed by Pyotr Avin. Center for the National Interest, CNI, U.S.-based think tank with expertise in and connections to Russia. CNI's publication, The National Interest, hosted candidate Trump's foreign policy speech in April 2016. Concord, umbrella term for Concord Management and Consulting, LLC, and Concord Catering, which are Russian companies controlled by Yevgeny Prigozhin. Crocus Group, or Crocus International, a Russian real estate and property development company that, in 2013, hosted the Miss Universe pageant, and from 2013 through 2014 worked with the Trump Organization on a Trump Moscow project. DC Leaks, fictitious online persona operated by the GRU that released stolen documents during the 2016 U.S. presidential campaign period. Democratic Congressional Campaign Committee, political committee working to elect Democrats to the House of Representatives, hacked by the GRU in April 2016. Democratic National Committee, formal governing body for the Democratic Party, hacked by the GRU in April 2016. Duma, lower house of the National Legislature of the Russian Federation. Gazprom, Russian oil and gas company, majority owned by the Russian government. Global Energy Capital, LLC, investment and management firm founded by Carter Page. Global Partners in Diplomacy, event hosted in partnership with the U.S. Department of State and the Republican National Convention. In 2016, Jeff Sessions and J.D. Gordon delivered speeches at the event and interacted with Russian Ambassador Sergei Kislyak. Guccifer 2.0, fictitious online persona operated by the GRU that released stolen documents during the 2016 U.S. presidential campaign period. IC Expert Investment Company, Russian real estate and development corporation that signed a letter of intent with a Trump Organization subsidiary to develop a Trump Moscow property. Internet Research Agency, IRA, Russian entity based in St. Petersburg and funded by Concord that engaged in an active measures social media campaign to interfere in the 2016 U.S. presidential election. KLS Research LLC, business established by an associate of and at the direction of Peter Smith to further Smith's search for Hillary Clinton emails. Kremlin, official residence of the President of the Russian Federation. It is used colloquially to refer to the office of the President or the Russian government. Letter 1. Company that includes Pyotr Oven and Richard Burt as board members. During a board meeting in December 2016, Oven asked for Burt's help to make contact with the presidential transition team. Link Campus University, University in Rome, Italy, where George Papadopoulos was introduced to Joseph Mifsud. London Centre of International Law Practice, LCILP, international law advisory organization in London that employed Joseph Mifsud and George Papadopoulos. Main Intelligence Directorate of the General Staff, GRU, Russian Federation's military intelligence agency. New Economic School in Moscow, NES, Moscow-based school that invited Carter Page to speak at its July 2016 commencement ceremony. Opposition Bloc, Ukrainian political party that incorporated members of the defunct Party of Regions. Party of Regions, Ukrainian political party of former President Yanukovych. It was generally understood to align with Russian policies. Pericles Emerging Market Partners LLP, company registered in the Cayman Islands by Paul Manafort and his business partner Rick Davis. Oleg Deripaska invested in the fund. Previzon Holdings Limited, Russian company that was a defendant in a U.S. civil action alleging the laundering of proceeds from fraud exposed by Sergei Magnitsky. Rose Congress Foundation, Russian entity that organized the St. Petersburg International Economic Forum. Rosneft, Russian state-owned oil and energy company. Russian Direct Investment Fund, sovereign wealth fund established by the Russian government in 2011 and headed by Kirill Dmitriev. Russian International Affairs Council, Russia-based nonprofit established by Russian government decree. It is associated with the Ministry of Foreign Affairs, and its members include Ivan Timofeyev, Dmitry Peskov, and Pyotr Avin. Silk Road Group, privately held investment company that entered into a licensing agreement to build a Trump-branded hotel in Georgia. St. Petersburg International Economic Forum, annual event held in Russia and attended by prominent Russian politicians and businessmen. Tatneft, Russian energy company. Transatlantic Parliamentary Group on Counterterrorism, European group that sponsored a summit between European Parliament lawmakers and U.S. persons. George Papadopoulos, Sam Clovis, and Walid Faraz attended the TAG summit in July 2016. Unit 26165, GRU. GRU Military Cyber Unit dedicated to targeting military, political, governmental, and non-governmental organizations outside of Russia. It engaged in computer intrusions of U.S. persons and organizations, as well as the subsequent release of the stolen data, in order to interfere in the 2016 U.S. presidential election. Unit 74455, GRU. GRU military unit with multiple departments that engaged in cyber operations. It engaged in computer intrusions of U.S. persons and organizations, as well as the subsequent release of the stolen data in order to interfere with the 2016 presidential election. Valdai Discussion Club, group that holds a conference attended by Russian government officials, including President Putin. WikiLeaks, organization founded by Julian Assange that posts information online, including data stolen from private, corporate, and U.S. government entities. Released data stolen by the GRU during the 2016 U.S. presidential election. Index of Acronyms. CNI, Center for the National Interest. DCCC, or DCCC. Democratic Congressional Campaign Committee. DNC, Democratic National Committee. FBI, Federal Bureau of Investigation. FSB, Russian Federal Security Service. GEC, Global Energy Capital, LLC. GRU, Russian Federation's main intelligence directorate of the General Staff. HPSCI, U.S. House of Representatives Permanent Select Committee on Intelligence. HRC, Hillary Rodham Clinton. IRA, Internet Research Agency. LCILP, London Centre of International Law Practice. NATO, NATO, North Atlantic Treaty Organization. NES, New Economic School. NSA, National Security Agency. ODNI, Office of the Director of National Intelligence. PTT, Presidential Transition Team. RDIF, Russian Direct Investment Fund. RIAC, Russian International Affairs Council. SBOE, State Boards of Elections. SCO, Special Counsel's Office. SJC, U.S. Senate Judiciary Committee. SSCI, U.S. Senate Select Committee on Intelligence. TAG, Transatlantic Parliamentary Group on Counterterrorism. VEB, Vinesh Ekonombank. End of Section 24. Recording by Amy Conger, San Francisco, California.
Section 25 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kathleen Nelson. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller, Section 25, Appendix C. Introductory Note. The President provided written responses through his personal counsel to questions submitted to him by the Special Counsel's Office. We first explained the process that led to the submission of written questions and then attached the President's responses. Beginning in December 2017, this office sought for more than a year to interview the President on topics relevant to both Russian election interference and obstruction of justice. We advised counsel that the President was a subject of the investigation under the definition of the Justice Manual, a person whose conduct is within the scope of the grand jury's investigation. Justice Manual Section 9 through 11.151, 2018. We also advised counsel that an interview with the President is vital to our investigation, and that this office had carefully considered the constitutional and other arguments raised by counsel, and they did not provide us with reason to forego seeking an interview. We additionally stated that it is in the interest of the presidency and the public for an interview to take place, and offered numerous accommodations to aid the President's preparation and avoid surprise. After extensive discussions with the Department of Justice about the Special Counsel's objective of securing the President's testimony, these accommodations included the submission of written questions to the President on certain Russia-related topics. We received the President's written responses in late November 2018. In December 2018, we informed counsel of the insufficiency of those responses in several respects. We noted, among other things, that the President stated on more than 30 occasions that he does not recall or remember or have an independent recollection of information called for by the questions. Other answers were incomplete or imprecise. The written responses, we informed counsel, demonstrate the inadequacy of the written format as we have had no opportunity to ask follow-up questions that would ensure complete answers and potentially refresh your client's recollection or clarify the extent or nature of his lack of recollection. We again requested an in-person interview limited to certain topics, advising the President's counsel that this is the President's opportunity to voluntarily provide us with information for us to evaluate in the context of all the evidence we have gathered. The President declined. Redaction, Grand Jury. Recognizing that the President would not be interviewed voluntarily, we considered whether to issue a subpoena for his testimony. We viewed the written answers to be inadequate. But at that point, our investigation had made significant progress and had produced substantial evidence for our report. We thus weighed the costs of potentially lengthy constitutional litigation, with resulting delay in finishing our investigation, against the anticipated benefits for our investigation and report. As explained in Volume 2, Section 2, Part B, we determined that the substantial quantity of information we had obtained from other sources allowed us to draw relevant factual conclusions on intent and credibility, which are often inferred from circumstantial evidence and assessed without direct testimony from the subject of the investigation. 1. June 9, 2016 meeting at Trump Tower. A. When did you first learn that Donald Trump Jr., Paul Manafort, or Jared Kushner was considering participating in a meeting in June 2016 concerning potentially negative information about Hillary Clinton? Describe who you learned the information from and the substance of the discussion. B. Attached to this document as Exhibit A is a series of emails from June 2016 between, among others, Donald Trump Jr. and Rob Goldstone. In addition to the emails reflected in Exhibit A, Donald Trump Jr. had other communications with Rob Goldstone and Amin Agalarov between June 3, 2016 and June 9, 2016. 1. Did Mr. Trump Jr. or anyone else tell you about or show you any of these communications? If yes, describe who discussed the communications with you, when, and the substance of the discussions. 2. When did you first see or learn about all or any part of the emails reflected in Exhibit A? 3. When did you first learn that the proposed meeting involved or was described as being part of Russia and its government's support for your candidacy? 4. Did you suggest or direct anyone not to discuss or release publicly all or any portions of the emails reflected in Exhibit A? If yes, describe who you communicated with, when, the substance of the communications, and why you took that action. C. On June 9, 2016, Donald Trump Jr., Paul Manafort, and Jared Kushner attended a meeting at Trump Tower with several individuals, including a Russian lawyer, Natalia Veselnitskaya, the June 9 meeting. 1. Other than as set forth in your answers to 1A and 1B, what, if anything, were you told about the possibility of this meeting taking place, or the scheduling of such a meeting? Describe who you discussed this with, when, and what you were informed about the meeting. 2. When did you learn that some of the individuals attending the June 9 meeting were Russian or had any affiliation with any part of the Russian government? Describe who you learned this information from and the substance of the discussions. 3. What were you told about what was discussed at the June 9 meeting? Describe each conversation in which you were told about what was discussed at the meeting, who the conversation was with, when it occurred, and the substance of the statements they made about the meeting. 4. Were you told that the June 9 meeting was about, in whole or in part, adoption and/or the Magnitsky Act? If yes, describe who you had that discussion with, when, and the substance of the discussion. D. For the period June 6, 2016 through June 9, 2016, for what portion of each day were you in Trump Tower? 1. Did you speak or meet with Donald Trump Jr., Paul Manafort, or Jared Kushner on June 9, 2016? If yes, did any portion of those conversations or meetings include any reference to any aspect of the June 9 meeting? If yes, describe who you spoke with and the substance of the conversation. E. Did you communicate directly or indirectly with any member or representative of the Agalarov family after June 3, 2016? If yes, describe who you spoke with, when, and the substance of the communication. F. Did you learn of any communications between Donald Trump Jr., Paul Manafort, or Jared Kushner and any member or representative of the Agalarov family, Natalia Veselnitskaya, Rob Goldstone, or any Russian official or contact that took place after June 9, 2016, and concerned the June 9 meeting or efforts by Russia to assist the campaign? If yes, describe who you learned this information from, when, and the substance of what you learned. G. On June 7, 2016, you gave a speech in which you said, in part, I am going to give a major speech on probably Monday of next week, and we're going to be discussing all of the things that have taken place with the Clintons. 1. Why did you make that statement? 2. What information did you plan to share with respect to the Clintons? 3. What did you believe the sources of that information would be? 4. Did you expect any of the information to have come from the June 9 meeting? 5. Did anyone help draft the speech that you were referring to? If so, who? 6. Why did you ultimately not give the speech you referenced on June 7, 2016? H. Did any person or entity inform you during the campaign that Vladimir Putin or the Russian government supported your candidacy or opposed the candidacy of Hillary Clinton? If yes, describe the sources of the information, when you were informed, and the content of such discussions. I. Did any person or entity inform you during the campaign that any foreign government or foreign leader, other than Russia or Vladimir Putin, had provided, wished to provide, or offered to provide tangible support to your campaign, including by way of offering to provide negative information on Hillary Clinton? If yes, describe the sources of the information, when you were informed, and the content of such discussions. 2. Russian hacking / Russian efforts using social media / WikiLeaks. A. On June 14, 2016, it was publicly reported that computer hackers had penetrated the computer network of the Democratic National Committee, DNC, and that Russian intelligence was behind the unauthorized access or hack. Prior to June 14, 2016, were you provided any information about any potential or actual hacking of the computer systems or email accounts of the DNC, the Democratic Congressional Campaign Committee, DCCC, the Clinton campaign, Hillary Clinton, or individuals associated with the Clinton campaign? If yes, describe who provided this information, when, and the substance of the information. B. On July 22, 2016, WikiLeaks released nearly 20,000 emails sent or received by Democratic Party officials. 1. Prior to the July 22, 2016 release, were you aware from any source that WikiLeaks, Guccifer 2.0, DC Leaks, or Russians had or potentially had possession of or planned to release emails or information that could help your campaign or hurt the Clinton campaign? If yes, describe who you discussed this issue with, when, and the substance of the discussions. 2. After the release of emails by WikiLeaks on July 22, 2016, were you told that WikiLeaks possessed or might possess additional information that could be released during the campaign? If yes, describe who provided this information, when, and what you were told. C. Are you aware of any communications during the campaign, directly or indirectly, between Roger Stone, Donald Trump Jr., Paul Manafort, or Rick Gates and A. WikiLeaks, B. Julian Assange, C. Other representatives of WikiLeaks, D. Guccifer 2.0, E. Representatives of Guccifer 2.0, or F. Representatives of DC Leaks? If yes, describe who provided you with this information, when you learned of the communications, and what you know about those communications. D. On July 27, 2016, you stated at a press conference, "Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press." 1. Why did you make that request of Russia as opposed to any other country, entity, or individual? 2. In advance of making that statement, what discussions, if any, did you have with anyone else about the substance of the statement? 3. Were you told at any time before or after you made that statement that Russia was attempting to infiltrate or hack computer systems or email accounts of Hillary Clinton or her campaign? If yes, describe who provided this information, when, and what you were told. E. On October 7, 2016, emails hacked from the account of John Podesta were released by WikiLeaks. 1. Where were you on October 7, 2016? 2. Were you told at any time in advance of or on the day of the October 7 release that WikiLeaks possessed or might possess emails related to John Podesta? If yes, describe who told you this, when, and what you were told. 3. Are you aware of anyone associated with you or your campaign, including Roger Stone, reaching out to WikiLeaks either directly or through an intermediary on or about October 7, 2016? If yes, identify the persons and describe the substance of the conversations or contacts. F. Were you told of anyone associated with you or your campaign, including Roger Stone, having any discussions directly or indirectly with WikiLeaks, Guccifer 2.0, or DC Leaks regarding the content or timing of release of hacked emails? If yes, describe who had such contacts, how you became aware of the contacts, when you became aware of the contacts, and the substance of the contacts. G. From June 1, 2016 through the end of the campaign, how frequently did you communicate with Roger Stone? Describe the nature of your communications with Mr. Stone. 1. During that time period, what efforts did Mr. Stone tell you he was making to assist your campaign, and what requests, if any, did you make of Mr. Stone? 2. Did Mr. Stone ever discuss WikiLeaks with you, or, as far as you were aware, with anyone else associated with the campaign? If yes, describe what you were told, from whom, and when. 3. Did Mr. Stone at any time inform you about contacts he had with WikiLeaks or any intermediary of WikiLeaks, or about forthcoming releases of information? If yes, describe what Stone told you and when. H. Did you have any discussions prior to January 20, 2017 regarding a potential pardon or other action to benefit Julian Assange? If yes, describe who you had the discussions with, when, and the content of the discussions. I. Were you aware of any efforts by foreign individuals or companies, including those in Russia, to assist your campaign through the use of social media postings or the organization of rallies? If yes, identify who you discussed such assistance with, when, and the content of the discussions. 3. The Trump Organization Moscow Project. A. In October 2015, a letter of intent, a copy of which is attached as Exhibit B, was signed for a proposed Trump Organization project in Moscow, the Trump Moscow Project. 1. When were you first informed of discussions about the Trump Moscow Project? By whom? What were you told about the project? 2. Did you sign the letter of intent? B. In a statement provided to Congress attached as Exhibit C, Michael Cohen stated, "To the best of my knowledge, Mr. Trump was never in contact with anyone about this proposal other than me on 3 occasions, including signing a non-binding letter of intent in 2015. Describe all discussions you had with Mr. Cohen or anyone else associated with the Trump Organization about the Trump Moscow Project, including who you spoke with, when, and the substance of the discussions. C. Did you learn of any communications between Michael Cohen or Felix Sater and any Russian government officials, including officials in the office of Dmitry Peskov, regarding the Trump Moscow Project? If so, identify who provided this information to you, when, and the substance of what you learned. D. Did you have any discussions between June 2015 and June 2016 regarding a potential trip to Russia by you and or Michael Cohen for reasons related to the Trump Moscow Project? If yes, describe who you spoke with, when, and the substance of the discussions. E. Did you at any time direct or suggest that discussions about the Trump Moscow Project should cease? Or were you informed at any time that the project had been abandoned? If yes, describe who you spoke with, when, the substance of the discussions, and why that decision was made. F. Did you have any discussions regarding what information would be provided publicly or in response to investigative inquiries about potential or actual investments or business deals the Trump Organization had in Russia, including the Trump Moscow Project? If yes, describe who you spoke with, when, and the substance of the discussions. G. Aside from the Trump Moscow Project, did you or the Trump Organization have any other prospective or actual business interests, investments, or arrangements with Russia or any Russian interest or Russian individual during the campaign? If yes, describe the business interests, investments, or arrangements. 4. Contacts with Russia and Russia-related issues during the campaign. A. Prior to mid-August 2016, did you become aware that Paul Manafort had ties to the Ukrainian government? If yes, describe who you learned this information from, when, and the substance of what you were told. Did Mr. Manafort's connections to the Ukrainian or Russian governments play any role in your decision to have him join your campaign? If yes, describe that role. B. Were you aware that Paul Manafort offered briefings on the progress of your campaign to Oleg Deripaska? If yes, describe who you learned this information from, when, the substance of what you were told, what you understood the purpose was of sharing such information with Mr. Deripaska, and how you responded to learning this information. C. Were you aware of whether Paul Manafort or anyone else associated with your campaign sent or directed others to send internal Trump campaign information to any person located in Ukraine or Russia or associated with Ukrainian or Russian governments? If yes, identify who provided you with this information, when, the substance of the discussions, what you understood the purpose was of sharing the internal campaign information, and how you responded to learning this information. D. Did Paul Manafort communicate to you, directly or indirectly, any positions Ukraine or Russia would want the U.S. to support? If yes, describe when he communicated those positions to you and the substance of those communications. E. During the campaign, were you told about efforts by Russian officials to meet with you or senior members of your campaign? If yes, describe who you had conversations with on this topic, when, and what you were told. F. What role, if any, did you have in changing the Republican Party platform regarding arming Ukraine during the Republican National Convention? Prior to the convention, what information did you have about this platform provision? After the platform provision was changed, who told you about the change? When did they tell you? What were you told about why it was changed? And who was involved? G. On July 27, 2016, in response to a question about whether you would recognize Crimea as Russian territory and lift sanctions on Russia, you said, "We'll be looking into that." Yeah, we'll be looking. Did you intend to communicate by that statement or at any other time during the campaign a willingness to lift sanctions and or recognize Russia's annexation of Crimea if you were elected? I. What consideration did you give to lifting sanctions and or recognizing Russia's annexation of Crimea if you were elected? Describe who you spoke with about this topic. When? The substance of the discussions. 5. Contacts with Russia and Russia-related issues during the transition. A. Were you asked to attend the World Chess Championship Gala on November 10, 2016? If yes, who asked you to attend? When were you asked? And what were you told about why your presence was requested? 1. Did you attend any part of the event? If yes, describe any interactions you had with any Russians or representatives of the Russian government at the event. B. Following the Obama administration's imposition of sanctions on Russia in December 2016, Russia's sanctions, did you discuss with Lieutenant General, LTG, Michael Flynn, KT McFarland, Steve Bannon, Reince Priebus, Jared Kushner, Eric Prince, or anyone else associated with the transition what should be communicated to the Russian government regarding the sanctions? If yes, describe who you spoke with about this issue, when, and the substance of the discussions. C. On December 29 and December 31, 2016, LTG Flynn had conversations with Russian Ambassador Sergei Kislyak about the Russia sanctions and Russia's response to the Russian sanctions. 1. Did you direct or suggest that LTG Flynn have discussions with anyone from the Russian government about the Russia sanctions? 2. Were you told in advance of LTG Flynn's December 29, 2016 conversation that he was going to be speaking with Ambassador Kislyak? If yes, describe who told you this information, when, and what you were told. If no, when and from whom did you learn of LTG Flynn's December 29, 2016 conversation with Ambassador Kislyak? 3. When did you learn of LTG Flynn and Ambassador Kislyak's call on December 31, 2016? Who told you and what were you told? 4. When did you learn that sanctions were discussed in the December 29 and December 31, 2016 calls between LTG Flynn and Ambassador Kislyak? Who told you and what were you told? D. At any time between December 31, 2016 and January 20, 2017, did anyone tell you or suggest to you that Russia's decision not to impose reciprocal sanctions was attributable in any way to LTG Flynn's communications with Ambassador Kislyak? If yes, identify who provided you with this information, when, and the substance of what you were told. E. On January 12, 2017, the Washington Post published a column stating that LTG Flynn phoned Ambassador Kislyak several times on December 29, 2016. After learning of the column, did you direct or suggest to anyone that LTG Flynn should deny that he discussed sanctions with Ambassador Kislyak? If yes, who did you make the suggestion or direction to? When? What did you say? And why did you take this step? I. After learning of the column, did you have any conversations with LTG Flynn about his conversations with Ambassador Kislyak in December 2016? If yes, describe when those discussions occurred and the content of the discussions. F. Were you told about a meeting between Jared Kushner and Sergei Gorkov that took place in December 2016? 1. If yes, describe who you spoke with, when, the substance of the discussions, and what you understood was the purpose of the meeting. G. Were you told about a meeting or meetings between Eric Prince and Kirill Dmitriev or any other representative from the Russian government that took place in January 2017? 1. If yes, describe who you spoke with, when, the substance of the discussions, and what you understood was the purpose of the meeting. H. Prior to January 20, 2017, did you talk to Steve Bannon, Jared Kushner, or any other individual associated with the transition regarding establishing an unofficial line of communication with Russia? If yes, describe who you spoke with, when, the substance of the discussions, and what you understood was the purpose of such an unofficial line of communication. Responses of President Donald J. Trump. 1. June 9, 2016, meeting at Trump Tower. A. When did you first learn that Donald Trump Jr., Paul Manafort, or Jared Kushner was considering participating in a meeting in June 2016 concerning potentially negative information about Hillary Clinton? Describe who you learned the information from and the substance of the discussion. B. Attached to this document as Exhibit A is a series of emails from June 2016 between, among others, Donald Trump Jr. and Rob Goldstone. In addition to the emails reflected in Exhibit A, Donald Trump Jr. had other communications with Rob Goldstone and Amin Agalarov between June 3, 2016 and June 9, 2016. 1. Did Mr. Trump Jr. or anyone else tell you about or show you any of these communications? If yes, describe who discussed the communications with you, when, and the substance of the discussions. 2. When did you first see or learn about all or any part of the emails reflected in Exhibit A? 3. When did you first learn that the proposed meeting involved or was described as being part of Russia's and its government's support for your candidacy? 4. Did you suggest to or direct anyone not to discuss or release publicly all or any portion of the emails reflected in Exhibit A? If yes, describe who you communicated with, when, the substance of the communications, and why you took that action. C. On June 9, 2016, Donald Trump Jr., Paul Manafort, and Jared Kushner attended a meeting at Trump Tower with several individuals, including a Russian lawyer, Natalia Veselnitskaya, the June 9 meeting. 1. Other than as set forth in your answers to 1A and 1B, what, if anything, were you told about the possibility of this meeting taking place or the scheduling of such a meeting? Describe who you discussed this with, when, and what you were informed about the meeting. 2. When did you learn that some of the individuals attending the June 9 meeting were Russian or had any affiliation with any part of the Russian government? Describe who you learned this information from and the substance of the discussions. 3. What were you told about what was discussed at the June 9 meeting? Describe each conversation in which you were told about what was discussed at the meeting, who the conversation was with, when it occurred, and the substance of the statements they made about the meeting. 4. Were you told that the June 9 meeting was about, in whole or in part, adoption and/or the Magnitsky Act? If yes, describe who you had that discussion with, when, and the substance of the discussion. D. For the period June 6, 2016 through June 9, 2016, for what portion of each day were you in Trump Tower? 1. Did you speak or meet with Donald Trump Jr., Paul Manafort, or Jared Kushner on June 9, 2016? If yes, did any portion of those conversations or meeting include any reference to any aspect of the June 9 meeting? If yes, describe who you spoke with and the substance of the conversation. E. Did you communicate directly or indirectly with any member or representative of the Agalarov family after June 3, 2016? If yes, describe who you spoke with, when, and the substance of the communications. F. Did you learn of any communications between Donald Trump Jr., Paul Manafort, or Jared Kushner and any member or representative of the Agalarov family, Natalia Veselnitskaya, Rob Goldstone, or any Russian official or contact that took place after June 9, 2016 and concerned the June 9 meeting or efforts by Russia to assist the campaign? If yes, describe who you learned this information from, when, and the substance of what you learned. G. On June 7, 2016, you gave a speech in which you said, in part, I am going to give a major speech on probably Monday of next week, and we're going to be discussing all of the things that have taken place with the Clintons. 1. Why did you make that statement? 2. What information did you plan to share with respect to the Clintons? 3. What did you believe the sources of that information would be? 4. Did you expect any of the information to have come from the June 9 meeting? 5. Did anyone help draft the speech that you were referring to? If so, who? H. Did any person or entity inform you during the campaign that Vladimir Putin or the Russian government supported your candidacy or opposed the candidacy of Hillary Clinton? If yes, describe the sources of the information, when you were informed, and the content of any such discussions. I. Did any person or entity inform you during the campaign that any foreign government or foreign leader other than Russia or Vladimir Putin had provided, wished to provide, or offered to provide tangible support to your campaign, including by way of offering to provide negative information on Hillary Clinton? If yes, describe the sources of the information, when you were informed, and the content of such discussions. Response to question 1, parts A through C. I have no recollection of learning at the time that Donald Trump Jr., Paul Manafort, or Jared Kushner was considering participating in a meeting in June 2016 concerning potentially negative information about Hillary Clinton. Nor do I recall learning during the campaign that the June 9, 2016 meeting had taken place, that the referenced emails existed, or that Donald J. Trump Jr. had other communications with Amin Agalarov or Rob Goldstone between June 3, 2016 and June 9, 2016. Response to question 1, part D. I have no independent recollection of what portion of these 4 days in June of 2016 I spent in Trump Tower. This was one of many busy months during a fast-paced campaign as the primary season was ending and we were preparing for the general election campaign. I am now aware that my campaign's calendar indicates that I was in New York City from June 6 through 9, 2016. Calendars kept in my Trump office reflect that I had various calls and meetings scheduled for each of these days. While those calls and meetings may or may not have actually taken place, they do indicate that I was in Trump Tower during a portion of each of these working days, and I have no reason to doubt that I was. When I was in New York City, I stayed at my Trump Tower apartment. My Trump Organization desk calendar also reflects that I was outside Trump Tower during portions of these days. The June 7, 2016 calendar indicates I was scheduled to leave Trump Tower in the early evening for Westchester, where I gave remarks after winning the California, New Jersey, New Mexico, Montana, and South Dakota Republican primaries held that day. The June 8, 2016 calendar indicates a scheduled departure in late afternoon to attend a ceremony at my son's school. The June 9, 2016 calendar indicates I was scheduled to attend midday meetings and a fundraising luncheon at the Four Seasons Hotel. At this point, I do not remember on what dates these events occurred, but I do not currently have a reason to doubt that they took place as scheduled on my calendar. Widely available media reports, including television footage, also shed light on my activities during these days. For example, I am aware that my June 7, 2016 victory remarks at the Trump National Golf Club in Briarcliff Manor, New York, were recorded and published by the media. I remember winning those primaries and generally recall delivering remarks that evening. At this point, I do not remember whether I spoke or met with Donald Trump Jr., Paul Manafort, or Jared Kushner on June 9, 2016. My desk calendar indicates I was scheduled to meet with Paul Manafort on the morning of June 9, but I do not recall if that meeting took place. It was more than 2 years ago, at a time when I had many calls and interactions daily. Response to Question 1, Part E. I have no independent recollection of any communications I had with the Agalarov family or anyone I understood to be a representative of the Agalarov family after June 3, 2016, and before the end of the campaign. While preparing to respond to these questions, I have become aware of written communications with the Agalarovs during the campaign that were sent, received, and largely authored by my staff, and which I understand have already been produced to you. In general, the documents include congratulatory letters on my campaign victories, emails about a painting Amin and Aras Agalarov arranged to have delivered to Trump Tower as a birthday present, and emails regarding delivery of a book written by Aras Agalarov. The documents reflect that the deliveries were screened by the Secret Service. Response to Question 1, Part F. I do not recall being aware during the campaign of communications between Donald Trump Jr., Paul Manafort, or Jared Kushner, and any member or representative of the Agalarov family, Robert Goldstone, Natalia Veselnitskaya, whose name I was not familiar with, or anyone understood to be a Russian official. Response to Question 1, Part G. In remarks I delivered the night I won the California, New Jersey, New Mexico, Montana, and South Dakota Republican primaries, I said, I am going to give a major speech on probably Monday of next week, and we're going to be discussing all of the things that have taken place with the Clintons. In general, I expected to give a speech referencing the publicly available negative information about the Clintons, including, for example, Mrs. Clinton's failed policies, the Clintons' use of the State Department to further their interests and the interests of the Clinton Foundation, Mrs. Clinton's improper use of a private server for State Department business, the destruction of 33,000 emails on that server, and Mrs. Clinton's temperamental unsuitability for the office of president. In the course of preparing to respond to your questions, I have become aware that the campaign documents already produced to you reflect the drafting evolution and sources of information for the speech I expected to give probably on the Monday following my June 7, 2016 comments. These documents generally show that the text of the speech was initially drafted by campaign staff with input from various outside advisors and was based on publicly available material, including in particular information from the book Clinton Cash by Peter Schweitzer. The Pulse nightclub terrorist attack took place in the early morning hours of Sunday, June 12, 2016. In light of that tragedy, I gave a speech directed more specifically to national security and terrorism than to the Clintons. That speech was delivered at the St. Anselm College Institute of Politics in Manchester, New Hampshire, and as reported, opened with the following. This was going to be a speech on Hillary Clinton and how bad a president, especially in these times of radical Islamic terrorism, she would be. Even her former Secret Service agent, who has seen her under pressure and in times of stress, has stated that she lacks the temperament and integrity to be president. There will be plenty of opportunity to discuss these important issues at a later time, and I will deliver that speech soon. But today, there is only one thing to discuss: the growing threat of terrorism inside of our borders. I continued to speak about Mrs. Clinton's failings throughout the campaign, using the information prepared for inclusion in the speech to which I referred on June 7, 2016. Response to Question 1, Part H. I have no recollection of being told during the campaign that Vladimir Putin or the Russian government supported my candidacy or opposed the candidacy of Hillary Clinton. However, I was aware of some reports indicating that President Putin had made complimentary statements about me. Response to Question 1, Part I. I have no recollection of being told during the campaign that any foreign government or foreign leader had provided, wished to provide, or offered to provide tangible support to my campaign. 2. Russian hacking / Russian efforts using social media / WikiLeaks. A. On June 14, 2016, it was publicly reported that computer hackers had penetrated the computer network of the Democratic National Committee, DNC, and that Russian intelligence was behind the unauthorized access or hack. Prior to June 14, 2016, were you provided any information about any potential or actual hacking of the computer systems or email accounts of the DNC, the Democratic Congressional Campaign Committee, DCCC, the Clinton Campaign, Hillary Clinton, or individuals associated with the Clinton campaign? If yes, describe who provided this information, when, and the substance of the information. B. On July 22, 2016, WikiLeaks released nearly 20,000 emails sent or received by Democratic Party officials. 1. Prior to the July 22, 2016 release, were you aware from any source that WikiLeaks, Guccifer 2.0, DC Leaks, or Russians had or potentially had possession of or planned to release emails or information that could help your campaign or hurt the Clinton campaign? If yes, describe who you discussed this issue with, when, and the substance of the discussions. 2. After the release of emails by WikiLeaks on July 22, 2016, were you told that WikiLeaks possessed or might possess additional information that could be released during the campaign? If yes, describe who provided this information, when, and what you were told. C. Are you aware of any communications during the campaign directly or indirectly between Roger Stone, Donald Trump Jr., Paul Manafort, or Rick Gates and A. WikiLeaks, B. Julian Assange, C. Other representatives of WikiLeaks, D. Guccifer 2.0, E. Representatives of Guccifer 2.0, or F. Representatives of DC Leaks? If yes, describe who provided you with this information, when you learned of the communications, and what you know about those communications. D. On July 27, 2016, you stated at a press conference, Russia, if you're listening, I hope you're able to find the 30,000 emails that are missing. I think you will probably be rewarded mightily by our press. 1. Why did you make that request of Russia as opposed to any other country, entity, or individual? 2. In advance of making that statement, what discussions, if any, did you have with anyone else about the substance of the statement? 3. Were you told at any time before or after you made that statement that Russia was attempting to infiltrate or hack computer systems or email accounts of Hillary Clinton or her campaign? If yes, describe who provided this information, when, and what you were told. E. On October 7, 2016, emails hacked from the account of John Podesta were released by WikiLeaks. 1. Where were you on October 7, 2016? 2. Were you told at any time in advance of or on the day of the October 7 release that WikiLeaks possessed or might possess emails related to John Podesta? If yes, describe who told you this, when, and what you were told. 3. Are you aware of anyone associated with you or your campaign, including Roger Stone, reaching out to WikiLeaks, either directly or through an intermediary, on or about October 7, 2016? If yes, identify the person and describe the substance of the conversations or contacts. F. Were you told of anyone associated with you or your campaign, including Roger Stone, having any discussions directly or indirectly with WikiLeaks, Guccifer 2.0, or DC Leaks regarding the content or timing of release of hacked emails? If yes, describe who had such contacts, how you became aware of the contacts, when you became aware of the contacts, and the substance of the contacts. G. From June 1, 2016 through the end of the campaign, how frequently did you communicate with Roger Stone? Describe the nature of your communications with Mr. Stone. 1. During that time period, what efforts did Mr. Stone tell you he was making to assist your campaign, and what requests, if any, did you make of Mr. Stone? 2. Did Mr. Stone ever discuss WikiLeaks with you, or, as far as you are aware, with anyone else associated with the campaign? If yes, describe what you were told, from whom, and when. 3. Did Mr. Stone at any time inform you about contacts he had with WikiLeaks or any intermediary of WikiLeaks, or about forthcoming releases of information? If yes, describe what Mr. Stone told you and when. H. Did you have any discussions prior to January 20, 2017 regarding a potential pardon or other action to benefit Julian Assange? If yes, describe who you had the discussions with, when, and the content of the discussions. I. Were you aware of any efforts by foreign individuals or companies, including those in Russia, to assist your campaign through the use of social media postings or the organization of rallies? If yes, identify who you discussed such assistance with, when, and the content of the discussions. Response to Question 2, Part A. I do not remember the date on which it was publicly reported that the DNC had been hacked, but my best recollection is that I learned of the hacking at or shortly after the time it became the subject of media reporting. I do not recall being provided any information during the campaign about the hacking of any of the named entities or individuals before it became the subject of media reporting. Response to Question 2, Part B. I recall that in the months leading up to the election, there was considerable media reporting about the possible hacking and release of campaign-related information, and there was a lot of talk about this matter. At the time, I was generally aware of these media reports and may have discussed these issues with my campaign staff or others, but at this point in time, more than 2 years later, I have no recollection of any particular conversation, when it occurred, or who the participants were. Response to Question 2, Part C. I do not recall being aware during the campaign of any communications between the individuals named in Questions 2C and anyone I understood to be a representative of WikiLeaks or any of the other individuals or entities referred to in the question. Response to Question 2, Part D. I made the statement quoted in Question 2D in jest and sarcastically, as was apparent to any objective observer. The context of the statement is evident in the full reading or viewing of the July 27, 2016 press conference, and I refer you to the publicly available transcript and video of that press conference. I do not recall having any discussion about the substance of the statement in advance of the press conference. I do not recall being told during the campaign of any efforts by Russia to infiltrate or hack the computer systems or email accounts of Hillary Clinton or her campaign prior to them becoming the subject of media reporting, and I have no recollection of any particular conversation in that regard. Response to Question 2, Part E. I was in Trump Tower in New York City on October 7, 2016. I have no recollection of being told that WikiLeaks possessed or might possess emails related to John Podesta before the release of Mr. Podesta's emails was reported by the media. Likewise, I have no recollection of being told that Roger Stone, anyone acting as an intermediary for Roger Stone, or anyone associated with my campaign had communicated with WikiLeaks on October 7, 2016. Response to Question 2, Part F. I do not recall being told during the campaign that Roger Stone or anyone associated with my campaign had discussions with any of the entities named in the question regarding the content or timing of release of hacked emails. Response to Question 2, Part G. I spoke by telephone with Roger Stone from time to time during the campaign. I have no recollection of the specifics of any conversations I had with Mr. Stone between June 1, 2016 and November 8, 2016. I do not recall discussing WikiLeaks with him, nor do I recall being aware of Mr. Stone having discussed WikiLeaks with individuals associated with my campaign, although I was aware that WikiLeaks was the subject of media reporting and campaign-related discussion at the time. Response to Question 2, Part H. I do not recall having had any discussion during the campaign regarding a pardon or action to benefit Julian Assange. Response to Question 2, Part I. I do not recall being aware during the campaign of specific efforts by foreign individuals or media companies to assist my campaign through the use of social media postings or the organization of rallies. 3. The Trump Organization Moscow Project. A. In October 2015, a letter of intent, a copy of which is attached as Exhibit B, was signed for the proposed Trump Organization project in Moscow, the Trump Moscow Project. 1. When were you first informed of discussions about the Trump Moscow Project? By whom? What were you told about the project? 2. Did you sign the letter of intent? B. In a statement provided to Congress attached as Exhibit C, Michael Cohen stated, "To the best of my knowledge, Mr. Trump was never in contact with anyone about this proposal other than me on 3 occasions, including signing a non-binding letter of intent in 2015. Describe all discussions you had with Mr. Cohen or anyone else associated with the Trump Organization about the Trump Moscow Project, including who you spoke with, when, and the substance of the discussions. C. Did you learn of any communication between Michael Cohen or Felix Sater and any Russian government officials, including officials in the office of Dmitry Peskov, regarding the Trump Moscow Project? If so, identify who provided this information to you, when, and the substance of what you learned. D. Did you have any discussions between June 2015 and June 2016 regarding a potential trip to Russia by you and or Michael Cohen for reasons related to the Trump Moscow Project? If yes, describe who you spoke with, when, and the substance of the discussions. E. Did you at any time direct or suggest that discussions about the Trump Moscow Project should cease, or were you informed at any time that the project had been abandoned? If yes, describe who you spoke with, when, the substance of the discussions, and why that decision was made. F. Did you have any discussions regarding what information would be provided publicly or in response to investigative inquiries about potential or actual investments or business deals the Trump Organization had in Russia, including the Trump-Moscow project? If yes, describe who you spoke with, when, and the substance of the discussions. G. Aside from the Trump-Moscow project, did you or the Trump organization have any other prospective or actual business interests, investments, or arrangements with Russia or any Russian interest or Russian individual during the campaign? If yes, describe the business interests, investments, or arrangements. Response to question 3, parts A through G. Sometime in 2015, Michael Cohen suggested to me the possibility of a Trump Organization project in Moscow. As I recall, Mr. Cohen described this as a proposed project of a general type we have done in the past in a variety of locations. I signed the non-binding letter of intent attached to your questions as Exhibit B, which required no equity or expenditure on our end and was consistent with our ongoing efforts to expand into significant markets around the world. I had few conversations with Mr. Cohen on this subject. As I recall, they were brief and they were not memorable. I was not enthused about the proposal, and I do not recall any discussion of travel to Russia in connection with it. I do not remember discussing it with anyone else at the Trump Organization, although it is possible. I do not recall being aware at this time of any communications between Mr. Cohen or Felix Sater and any Russian government official regarding the letter of intent. In the course of preparing to respond to your questions, I have become aware that Mr. Cohen sent an email regarding the letter of intent to Mr. Peskov at a general public email account, which should show there was no meaningful relationship with people in power in Russia. I understand those documents already have been provided to you. I vaguely remember press inquiries and media reporting during the campaign about whether the Trump Organization had business dealings with Russia. I may have spoken with campaign staff or Trump Organization employees regarding responses to requests for information, but I have no current recollection of any particular conversation with whom I may have spoken, when, or the substance of any conversation. As I recall, neither I nor the Trump Organization had any projects or proposed projects in Russia during the campaign other than the letter of intent. 4. Contacts with Russia and Russia-related issues during the campaign. A. Prior to mid-August 2016, did you become aware that Paul Manafort had ties to the Ukrainian government? If yes, describe who you learned this information from, when, and the substance of what you were told. Did Mr. Manafort's connections to the Ukrainian or Russian governments play any role in your decision to have him join your campaign? If yes, describe that role. B. Were you aware that Mr. Manafort offered briefings on the progress of your campaign to Oleg Deripaska? If yes, describe who you learned this information from, when, the substance of what you were told, what you understood the purpose was of sharing such information with Mr. Deripaska, and how you responded to learning this information. C. Were you aware of whether Paul Manafort or anyone else associated with your campaign sent or directed others to send internal Trump campaign information to any person located in Ukraine or Russia or associated with Ukrainian or Russian governments? If yes, identify who provided you with this information, when, the substance of the discussions, what you understood the purpose was of sharing the internal campaign information, and how you responded to learning this information. D. Did Paul Manafort communicate to you, directly or indirectly, any positions Ukraine or Russia would want the U.S. to support? If yes, describe when he communicated those positions to you, and the substance of those communications. E. During the campaign, were you told about efforts by Russian officials to meet with you or senior members of your campaign? If yes, describe who you had conversations with on this topic, when, and what you were told. F. What role, if any, did you have in changing the Republican Party platform regarding arming Ukraine during the Republican National Convention? Prior to the convention, what information did you have about this platform provision? After the platform provision was changed, who told you about the change? When did they tell you? What were you told about why it was changed and who was involved? G. On July 27, 2016, in response to a question about whether you would recognize Crimea as Russian territory and lift sanctions on Russia, you said, "We'll be looking at that." Yeah, we'll be looking. Did you intend to communicate by that statement or at any other time during the campaign a willingness to lift sanctions and or recognize Russia's annexation of Crimea if you were elected? 1. What consideration did you give to lifting sanctions and or recognizing Russia's annexation of Crimea if you were elected? Describe who you spoke with about this topic, when, the substance of the discussions. Response to question 4, parts A through D. Mr. Manafort was hired primarily because of his delegate work for prior presidential candidates, including Gerald Ford, Ronald Reagan, George H.W. Bush, and Bob Dole. I knew that Mr. Manafort had done international consulting work, and at some time before Mr. Manafort left the campaign, I learned that he was somehow involved with individuals concerning Ukraine, but I do not remember the specifics of what I knew at the time. I had no knowledge of Mr. Manafort offering briefings on the progress of my campaign to an individual named Oleg Deripaska, nor do I remember being aware of Mr. Manafort or anyone else associated with my campaign sending or directing others to send internal Trump campaign information to anyone I knew to be in Ukraine or Russia at the time, or to anyone I understood to be a Ukrainian or Russian government employee or official. I do not remember Mr. Manafort communicating to me any particular positions Ukraine or Russia would want the United States to support. Response to question 4, part E. I do not recall being told during the campaign of efforts by Russian officials to meet with me or with senior members of my campaign. In the process of preparing to respond to these questions, I became aware that on March 17, 2016, my assistant at the Trump Organization, Rona Graf, received an email from a Sergei Pridhodko, who identified himself as a deputy prime minister of the Russian Federation, Foundation Roscongress, inviting me to participate in the St. Petersburg International Economic Forum to be held in June 2016. The documents show that Ms. Graf prepared for my signature a brief response declining the invitation. I understand these documents have already been produced to you. Response to question 4, part F. I have no recollection of the details of what, when, or from what source I first learned about the change to the platform amendment regarding arming Ukraine, but I generally recall learning of the issue as part of media reporting. I do not recall being involved in changing the language to the amendment. Response to question 4, part G. My statement did not communicate any position. 5. Contacts with Russia and Russia-related issues during the transition. A. Were you asked to attend the World Chess Championship Gala on November 10, 2016? If yes, who asked you to attend? When were you asked, and what were you told about, why your presence was requested? 1. Did you attend any part of the event? If yes, describe any interactions you had with any Russians or representatives of the Russian government at the event. Response to question 5, part A. I do not remember having been asked to attend the World Chess Championship Gala, and I did not attend the event. During the course of preparing to respond to these questions, I have become aware of documents indicating that in March of 2016, the president of the World Chess Federation invited the Trump Organization to host, at Trump Tower, the 2016 World Chess Championship match to be held in New York in November 2016. I have also become aware that in November 2016, there were press inquiries to my staff regarding whether I had plans to attend the tournament, which was not being held at Trump Tower. I understand these documents have already been provided to you. Executed on November 20th, 2018, Donald J. Trump, President of the United States. End of section 25. Section 26 of Report on the Investigation into Russian Interference in the 2016 Presidential Election. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kathleen Nelson. Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller. Section 26. Appendix D. Special Counsel's Office transferred, referred, and completed cases. This appendix identifies matters transferred or referred by the Special Counsel's Office, as well as cases prosecuted by the office that are now completed. A. Transfers. The Special Counsel's Office has concluded its investigation into links and coordination between the Russian government and individuals associated with the Trump campaign. Certain matters assigned to the office by the Acting Attorney General have not fully concluded as of the date of this report. After consultation with the Office of the Deputy Attorney General, the office has transferred responsibility for those matters to other components of the Department of Justice and the FBI. Those transfers include 1. United States versus Bijan Rafikian and Camille Akim Alpetkin, U.S. Attorney's Office for the Eastern District of Virginia, awaiting trial. The Acting Attorney General authorized the Special Counsel to investigate, among other things, possible criminal conduct by Michael Flynn in acting as an unregistered agent for the government of Turkey. See August 2, 2017 memorandum from Rod J. Rosenstein to Robert S. Mueller III. The Acting Attorney General later confirmed the Special Counsel's authority to investigate Rafikian and Alpetkin because they may have been jointly involved with Flynn in FARA-related crimes. See October 20, 2017 memorandum from Associate Deputy Attorney General Scott Schools to Deputy Attorney General Rod J. Rosenstein. On December 1, 2017, Flynn pleaded guilty to an information charging him with making false statements to the FBI about his contacts with the Russian ambassador to the United States. As part of that plea, Flynn agreed to a statement of the offense in which he acknowledged that the Foreign Agents Registration Act, FARA, documents he filed on March 7, 2017 contained materially false statements and omissions. Flynn's plea occurred before the Special Counsel had made a final decision on whether to charge Rafikian or Alpetkin. On March 27, 2018, after consultation with the Office of the Deputy Attorney General, the Special Counsel's Office referred the investigation of Rafikian and Alpetkin to the National Security Division, NSD, for any action it deemed appropriate. The Special Counsel's Office determined the referral was appropriate because the investigation of Flynn had been completed, and that investigation had proved the rationale for the office's investigation of Rafikian and Alpetkin. At NSD's request, the Eastern District of Virginia continued the investigation of Rafikian and Alpetkin. 2. United States versus Michael Flynn, U.S. Attorney's Office for the District of Columbia, awaiting sentencing. 3. United States versus Richard Gates, U.S. Attorney's Office for the District of Columbia, awaiting sentencing. 4. United States versus Internet Research Agency et al., Russian social media campaign, U.S. Attorney's Office for the District of Columbia, National Security Division, post-indictment, pre-arrest, and pre-trial. 5. United States versus Konstantin Kilimnik, U.S. Attorney's Office for the District of Columbia, post-indictment, pre-arrest. 6. United States versus Paul Manafort, U.S. Attorney's Office for the District of Columbia, U.S. Attorney's Office for the Eastern District of Virginia, post-conviction. 7. United States versus Viktor Netchko et al., Russian hacking operations, U.S. Attorney's Office for the Western District of Pennsylvania, National Security Division, post-indictment, pre-arrest. 8. United States versus William Samuel Patton, U.S. Attorney's Office for the District of Columbia, awaiting sentencing. The acting Attorney General authorized the special counsels to investigate aspects of Patton's conduct that related to another matter that was under investigation by the office. The investigation uncovered evidence of a crime. The U.S. Attorney's Office for the District of Columbia handled the prosecution of Patton. 9. Redacted harm to ongoing matter. Investigation ongoing. The acting Attorney General authorized the special counsel to investigate, among other things, crime or crimes arising out of payments Paul Manafort received from the Ukrainian government before and during the tenure of President Viktor Yanukovych. See August 2, 2017 memorandum from Rod J. Rosenstein to Robert S. Mueller III. The acting Attorney General later confirmed the special counsel's authority to investigate redacted harm to ongoing matter. On October 27, 2017, Paul Manafort and Richard Gates were charged in the District of Columbia with various crimes, including FARA, in connection with work they performed for Russian-backed political entities in Ukraine. On February 22, 2018, Manafort and Gates were charged in the Eastern District of Virginia with various other crimes in connection with the payments they received for work performed for Russia-backed political entities in Ukraine. During the course of its redaction, harm to ongoing matter, the Special Counsel's Office developed substantial evidence with respect to individuals and entities that were redacted, harm to ongoing matter. On February 23, 2018, Gates pleaded guilty in the District of Columbia to a multi-object conspiracy and to making false statements. The remaining charges against Gates were dismissed. Thereafter, in consultation with the Office of the Deputy Attorney General, the Special Counsel's Office closed the redacted harm to ongoing matter and referred them, redacted harm to ongoing matter, for further investigation as it deemed appropriate. The office based its decision to close those matters on its mandate, the indictments of Manafort, Gates's plea, and its determination as to how best to allocate its resources, among other reasons. Redacted harm to ongoing matter. At redacted harm to ongoing matter. Continued the investigation of those closed matters. 10. United States v. Roger Stone, U.S. Attorney's Office for the District of Columbia, awaiting trial. 11. Redacted harm to ongoing matter. Investigation ongoing. B. Referrals. During the course of the investigation, the office periodically identified evidence of potential criminal activity that was outside the scope of the special counsel's jurisdiction established by the acting Attorney General. After consultation with the Office of the Deputy Attorney General, the office referred that evidence to appropriate law enforcement authorities, principally other components of the Department of Justice and the FBI. Those referrals, listed alphabetically by subject, are summarized below. 1. Redacted, harm to ongoing matter. 2. Michael Cohen. During the course of the investigation, the Special Counsel's Office uncovered evidence of potential wire fraud and FICA violations pertaining to Michael Cohen. That evidence was referred to the U.S. Attorney's Office for the Southern District of New York and the FBI's New York Field Office. 3. Redacted, harm to ongoing matter. 4. Redacted, harm to ongoing matter. 5. Gregory Craig. Redacted, harm to ongoing matter. Skadden, Arps, Slate, Meager, and Flom, LLP. During the course of the FARA investigation of Paul Manafort and Rick Gates, the Special Counsel's Office uncovered evidence of potential FARA violations pertaining to redacted, harm to ongoing matter. Gregory Craig, Skadden, Arps, Slate, Meager, and Flom, LLP, Skadden, and their work on behalf of the government of Ukraine. After consultation with the NSD, the evidence regarding Craig, redacted, harm to ongoing matter, was referred to NSD, and NSD elected to partner with the U.S. Attorney's Office for the Southern District of New York and the FBI's New York Field Office. NSD later elected to partner on the Craig matter with the U.S. Attorney's Office for the District of Columbia. NSD retained and handled issues relating to Skadden itself. 6. Redacted, harm to ongoing matter. 7. Redacted, harm to ongoing matter. 8. Redacted, harm to ongoing matter. 9. Redacted, harm to ongoing matter. 10. Redacted, harm to ongoing matter. 11. Redacted, harm to ongoing matter. 12. Redacted, harm to ongoing matter. 13. Redacted, harm to ongoing matter. 14. Redacted, harm to ongoing matter. C. Completed prosecutions. In 3 cases prosecuted by the Special Counsel's Office, the defendants have completed or are about to complete their terms of imprisonment. Because no further proceedings are likely in any case, responsibility for them has not been transferred to any other office or component. 1. United States v. George Papadopoulos. Post-conviction, completed term of imprisonment, December 7, 2018. 2. United States v. Alex Vandersvan. Post-conviction, completed term of imprisonment, June 4, 2018. 3. United States v. Richard Pinedo. Post-conviction, currently in Residential Reentry Center. Release date May 13, 2019. End of Section 26. End of Report on the Investigation into Russian Interference in the 2016 Presidential Election by Robert Mueller.